Zoomer begins. YouTube stream. Okay. So then, click exit that screen by clicking on the red X in the upper right hand corner. I don't see a red X. That's not going to be it. Okay. Well, all right. Okay. Oh, oh. So, who are my jurors? I've got Magdalena. I've got Juror Di Giuseppe. I've got Juror McCoy. Those are my, okay, right. Okay, so do you guys recognize any of the advocates? Oh, wait, I guess they're not all on screen yet, so we better wait. Dr. LaGreca, Detective Booth, Advocate Nang, and Advocate Cadiz. Can you guys turn your cameras on so the jurors can see whether they recognize you and whether there are any conflicts? There we go. So does anybody have a conflict that we need to talk about? No?
No conflict.
Great. All right, then I'm going to give them.
Your Honor, my co-counsel is, I believe, in the waiting room right now. Ken Jackson.
Got it. Okay, I got them all. Oh, so we have one more to look at. Do you see your co-counsel on the screen now?
Yes, I do.
Oh, great. Okay, so, and I'm assuming unless anybody says something that we still don't have a conflict. Okay, all right, I'm gonna let them know. Are you guys hearing that bum that my computer does? Oh boy, I gotta figure out how to turn that off. Can you still hear me now? Okay, I hope that did it. We're just waiting for the all clear.
Could the jurors please get the prosecution and defense team numbers?
The prosecution is team 114.
The defense is team 15.
So prosecution is 114 and defense is 115?
Okay.
Just so we can clarify, the defense was given the number just 15.
All right. Everyone is here and we have received the message to get started. So I need to turn off the video of hide non-video participants. Okay. Okay. All right, here we go. Sorry about that. Calling the case of State of West Carolina versus Timothy Ray. My name is Judge Manuel. Scoring judges, please look to the two buttons on the lower left of your screen and turn off your audio and video. I've got you on non-video participants, but you know, just let's dot all I's. These should remain off until the trial ends. You should, the only people on the screen right now should be the advocates and me. That's what we've got. That's what we've got. All right. Can the attorneys please make their appearances? Starting with the prosecution.
Good morning, Your Honor. Kendra Jackson, J.A.
I cannot hear you.
Good morning, Your Honor. Can you hear me
Is
now?
that me? Hold on. Okay. Now I can hear you.
Good morning, Your Honor. Kendra Jackson, Jackson, for the people of Skelton County.
Thank you, Ms. Jackson.
Good morning, Your Honor. Yulit Symbol, spelled T-S-Y-M-B-A-L, also on behalf of the prosecution.
That's symbol?
Symbol, correct, Your Honor.
Got it. Okay.
And when Your Honor is prepared, we do have a few housekeeping matters and motions in limine we'd like to address in court this morning.
All right. Well, let's get the appearances from the defense first. Thank you.
Sure.
Good morning, Your Honor. My name is Alexandra McCormick, and I, along with my co-counsel,
Graham Marcus.
we represent the defendant in this case, Mr. Timothy Ray.
All right. Ms. Jackson, can you tell me what team number you are so that the jurors have that information?
Yes, Your Honor. We represent Team 114.
Team 114. And Ms. McCormick, can you tell me what team you are?
Team 15.
Team 15. Okay, I think that's 115 now. All right. So for the prosecution, you said you had some motions in limine and some housekeeping. Let's hear the motions in limine first. So who will that be?
Sure, Your Honor. Would you like to hear a brief recitation of the facts before I proceed?
Yeah.
Okay. The prosecution has charged the defendant, Timothy Ray, with 1 count of first-degree murder. On October 17th, 2018, the defendant was having breakfast with his son while he was working on his laptop. His 6-year-old son, Nathan, spilled his juice on the defendant's laptop, which destroyed it. Thereafter, the defendant proceeded to abuse his son through a series of torturous actions and ultimately strangled him to death. The defense will attempt to put this in.
We'll let them talk about it. Why don't you give me your motion?
Certainly, Your Honor. So our first motion, Your Honor, we have it on a good faith belief that the defense may offer testimony regarding the defendant's family history as well as trauma, childhood trauma, that is. And specifically, this would be brought in through their expert, Dr. Riley. This can be found on page 62, where he was interviewing the defendant's father, and the defendant's father told him that the defendant's mother was neglectful, suffering from some type of delusion, and so on and so forth. We move to exclude this evidence under unfair prejudice, FRE 403, irrelevance under FRE 401, and that would be all.
All right, who's going to address this on the defense side?
Your Honor, childhood trauma contributes to schizophrenia. That is the ultimate issue in this case. Our burden is to prove that Mr. Ray had schizophrenia, and our expert needs to be able to explain how he came to that opinion. Because childhood trauma and genetics contribute to a schizophrenia diagnosis, we would ask the court to allow the jury to hear these facts in order for the jury to properly weigh the credibility of both experts in this case. This would include the history of child abuse and genetics, and for that reason, we would ask that this testimony be allowed in.
Mr. Zimbal?
Yes, Your Honor. The DSM-5, which is the universally accepted guide that both experts rely upon to diagnose a patient with schizophrenia, does not list childhood trauma or family history as symptoms that are used to diagnose schizophrenia. While they certainly may be mere exacerbating factors, they are not listed as the 5 core symptoms that are used to diagnose schizophrenia. For this reason, they are irrelevant under the DSM-5. Furthermore, Your Honor, the childhood trauma and family history will inflame the passions of the jury and prevent them from being able to make a rational decision, as they are, excuse me, as they will have passions of pity evoked for the defendant by hearing that kind of testimony. So it'd be substantially unfairly prejudicial more than any probative value would offer.
I'm sorry,
Ms.
Your
McCormick,
Honor.
I'm going to give you the last word.
Your
I'm going to
Honor,
give you the last word.
this would be extremely relevant to the case today. The experts are not required to only rely on the DSM-5. In fact, but we anticipate that both experts will testify that they relied on more than just the DSM-5 to come to their conclusion. Both sides relied on the interviews that were conducted, which included this information, in order to form their final opinions in this case. Therefore, the jury should be able to hear how they came to that conclusion and why.
I'm inclined to agree. I'm going to allow this testimony, so I'm going to deny the motion.
Yes, Your Honor.
Do you have any other motion?
Yes, Your Honor. My co-counsel will now raise a second motion eliminate.
Ms. Jackson?
Your Honor, we have one other motion. We expect the defense to elicit testimony from Officer Cruz given in an evaluation of Dr. Riley regarding the defendant's mental competency. And we expect them to present this statement: the patient was seen seeing things and sleepwalking within 1 month. This statement can be found in Exhibit 9 of Dr. Riley's medical evaluation. Admitting this statement, Your Honor, would outweigh the prejudicial effect, the probative value of the prejudicial effect here. And we would like to move to exclude this statement according to Rule 801 as hearsay.
Who's going to address this on the defense side?
Your Honor, that would be me. As to the 801 hearsay issue, experts are allowed to use inadmissible hearsay when it goes to the expert's opinion and how they formed their opinion.
Let me stop for just a second. I'm a little confused. Is Officer Cruz going to testify?
He's not testifying in today's trial.
Okay. So the testimony that they're that they want to exclude is testimony through the expert?
Yes, that testimony would be coming through Major Riley.
Got it. Okay, continue with your argument.
And similar to our previous argument, sleepwalking, as well as seeing things, which is what was reported by Officer Cruz, goes to the ultimate issue of today's case. We know that both experts relied on the testimony of Officer Cruz in order to form their opinion because both relied on Major Riley's report to form this opinion. Our expert must be able to describe how he did so. Evidence of sleepwalking contributes to a disturbed sleep pattern, which is an associated factor of schizophrenia, which is included in the DSM-5. Seeing things is evidence of hallucinations, a symptom of schizophrenia, which is also included in the DSM-5. So we would ask that the court allow this testimony to be admitted in order for the jury to weigh the credibility of the experts and their final opinion.
Ms. Jackson, do you have a response?
Yes, Your Honor. In 2010, when this evaluation was provided to Major Riley gave little to no credence to Officer Cruz's statement. In fact, he claimed that Officer Cruz was unreliable and that he was a liar, suggesting his untrustworthiness. So we would request that this statement not be admitted because it was rarely relevant at that time. The weight given to it was minimal at best, and it wasn't as relevant as in Dr. Riley's report for our defendant in the murder of his son.
Well, that sounds like great cross material. So I'm going to deny the motion and allow you to cross the expert on that.
Thank you, Your Honor.
Any other motions from the prosecution?
Not at this time, Your Honor, no.
Okay, so let me hear the defense motions and then we'll hear housekeeping.
Yes, Your Honor. Calling your attention to page 4 of the case packet, item 6 of the pretrial order, we understand that there was a previous motion to suppress what has been denied based on constitutional grounds. At this time, we are asking to exclude any and all evidence of the interview between the defendant and Detective Booth pursuant to Federal Rules of Evidence 1002, the best evidence rule. As Your Honor heard during the pretrial hearing, Detective Booth stated that he was never put on notice that the defendant's mental state was going to be at issue, which was his reasoning for not preserving the recorded interview. During this interview, Mr. Ray began to show symptoms of schizophrenia, a fact at issue in today's trial. This interview was recorded and subsequently transcribed. Detective Booth did not request a copy of the recording, although it was available for him to do so. At the time, Mr. Ray began to ask questions of Detective Booth, including whether he was with the CIA. At that moment, the detective was put on notice to preserve the recording. He had 30 days to do so.
So what you're asking me to suppress the interview statements in the
Yes, Your
interview?
Honor.
Okay, I'm going to deny that motion. You can cross on that.
Understood.
Do you have any other any motions?
We do. We have just one more.
Okay.
Pursuant to Federal Rules of Evidence 801 hearsay, we would move to exclude any and all evidence used of the 3 phone searches made on Mr. Ray's phone. Those searches include countries that don't extradite for murder charges, how to get rid of a body, and will bleach destroy a body. We do admit per stipulation 1 that the evidence is authenticated. However, the state cannot prove that Mr. Ray made those searches. And further, it is not an admission by a party opponent. Mr. Ray did not admit to conducting those searches. Therefore, it cannot be authenticated.
But you've already admitted authentication.
We admitted that the phone searches, the screenshots of the phone searches are authentic. However, the state cannot prove authentication of who made those searches.
Prosecution, who's going to argue this?
Yes, Your Honor. As Detective Booth explained that he recovered those searches from the phone during a search of the defendant's belongings after the killing. There is no reason, no evidence, no facts that point to any discrediting of where the searches came from. The screenshots clearly show the name of the defendant, Timothy Ray, in the phone. They also show the searches that were made in his phone. There's no evidence, unless the defense has any to offer that would be new to the court today, as to the phone being in somebody else's hands or being searched by someone else. there's no reason to doubt that they were made by the defendant himself. And the defendant has not raised any objections to those searches prior to this moment.
Ms. McCormick?
Your Honor, the searches may be authentic, but the prosecution will not be able to lay the proper foundation of who made those searches. And for that reason, those searches should be excluded.
Your Honor, may I be heard?
Yes.
Detective Booth was the one who recovered those searches, so he would be able to lay the foundation for where they were obtained. Furthermore, to just address the hearsay argument once more, it would be admissible under 801D2 because it is a party opponent statement. And again, the phone screenshots do clearly show who the phone belonged to and who those searches were made by.
I tell you what, I'm going to defer ruling on this and see how it comes out in the evidence.
Understood, Your Honor.
All right, so now there are no more motions in limine, correct? All right, let's go to housekeeping. Prosecution, do you have any housekeeping?
Yes, Your Honor. Given the unique rules of this jurisdiction, may we request that all mid-trial objections be constructively deemed at sidebar?
Yes.
Thank you. And secondly, when we intend to introduce evidence through exhibits such as photos or reports, may we share our screens with the witnesses for the purpose of laying the proper foundation?
Yes.
Thank you. No more housekeeping matters from the prosecution.
Defense?
Yes, Your Honor, we just have a few. It is our understanding that the federal rules of evidence and federal rules of criminal procedure apply to this proceeding. Accordingly, pursuant to federal rules of evidence 615, we would ask the court to invoke the rule of sequestration and have all witnesses, with the exception of the defendant, and all expert witnesses constructively excluded from the courtroom at this time.
Isn't that everybody?
Constructively, Your Honor.
Right. No, what you're saying is that you want everybody constructively excluded except the defendant and the experts.
I'm sorry, and the officers, just the officers to be excluded. Sequestered, I apologize.
Do you have any objection to that, Mr. Simbaugh?
Well, Your Honor, the only thing I would say is if the experts may be present throughout the trial, then we would request that the officers would be able to partake or at least observe the proceedings as well and be able to testify to what they hear during the trial.
You know what? I'm going to grant that sequestration motion.
Yes, Your Honor.
Anything
Your Honor,
else?
Yes, we would also like to inform the court that all defense exhibits are pre-marked and with the clerk constructively.
My understanding is all the exhibits have been pre-marked. Is that correct, Mr. Simbaugh?
Yes, that's correct, Your Honor.
Okay, and we're going to use the pre-markings, right? We're going to put them. Both sides agree to use the pre-markings.
Yes, Your Honor.
Yes.
Okay. All right. Anything else?
No, that is all.
Okay. All right. Let's hear opening statements. I'm going to ask everybody to switch to gallery view. Oh, no, wait, I'm sorry. That's wrong. That's for the first witness. We're going to hear opening statements, so everyone should make sure that they are in speaker view. And attorneys, please remember to mute your audio while the opener is speaking. Ms. Jackson, you may proceed when you're ready. Why do I have two attorneys? There we go. Okay.
The greatest trick the devil ever pulled was trying to convince the world that he didn't exist. On October 17th, 2018, the defendant needed to make his 6-year-old understand that spilling juice all over his laptop was wrong. The defendant took his belt and wrapped it around his son's neck and pulled, then tried to get rid of the body. After searching how to get away with murder, after faking mental illness, The defendant tried to convince everyone that he isn't responsible, that it wasn't him, that he just lost control. Don't fall for his tricks. The defendant is the one who took Nathan from this to this, from a lively young little boy to spoiled remains in the middle of a state park. Good morning, my name is Kendra Jackson, and along with my co-counsel, we represent the people of West Carolina. And as a result of the defendant's actions on October 17th, 2018, he is charged with 1 degree of first-degree murder. The day began for Nathan Ray as an ordinary day. He woke up from his bed and headed to the kitchen to have breakfast with his father. He was having his favorite breakfast, Frosted Flakes, when he reached for his juice. But when Nathan reached for his juice, he accidentally knocked over and spilled his juice all over the defendant's laptop. The defendant became enraged and furious, a man whose wife was having an affair, who was in the middle of a divorce, needed to make Nathan understand. He decided that Nathan needed to be punished. The defendant then yelled at Nathan, so much so that Nathan ran to his room crying. But the defendant didn't stop there. He then forced Nathan to do jumping jacks and high knees exercises. But Nathan wouldn't stop crying. He wouldn't do the exercises. He would not listen. So the defendant left Nathan's bedroom, went down the hall into his own room, where he sat on his bed to calm down and reflect. And that's when he made his choice. The defendant grabbed a belt and returned to his sobbing son. In that room, the defendant whipped Nathan as Nathan's screams grew louder. The defendant then took that same belt, wrapped it around Nathan's tear-soaked neck, and pulled tight. Imagine the defendant, 6'2", 180 pounds, towering over Nathan's 3'9", 45-pound body. Nathan looking up to his father as he squeezed the life out of him. Nathan's cries and screams turning into gasps for air, then choking, then silence. The defendant then took Nathan's lifeless body, threw it in a trash bag, and dumped his only son in a shallow grave. Now, fast forward to 2 days later, when the defendant came into contact with Officer Wentz at a DUI checkpoint. Officer Wentz noticed some suspicious items in the defendant's backseat: trash bags, jugs of bleach. And this is important because a later search of the defendant's cell phone records will show that the defendant searched for countries that don't extradite for murder. How to get rid of a body. And listen to this. Will bleach destroy a body? The defendant later confessed to Detective Booth that he killed his son and was arrested for the murder of his only child. Now, I anticipate the defense is going to come up here and say that the defendant was suffering from schizophrenia, that he was in the midst of an episode when he killed his child. But that's wrong. We're going to bring an expert, Dr. LaGreca, a board-certified forensic psychiatrist with decades of experience. He will tell you that the only thing the defendant was suffering from was a bad case of malingering. He was faking it. That once he got caught, he exaggerated, if not made up symptoms, like hearing voices and seeing cameras in a microwave. That symptoms that he's never shared with anyone ever before. Not until he was caught red-handed for murdering his child. But the defense is going to try to convince you otherwise by calling Major Riley. When listening to his testimony, please be mindful that Major Riley is the only doctor who believed the defendant suffered from schizophrenia. Not the primary care physician, not Dr. LaGreca, not the jail site doctor, not even Major Riley himself. And he evaluated the defendant back in 2010. At the end of this trial, my co-counsel, Yuli Simbel, will stand before you. He's going to ask you to review the facts, to not stand for, not believe the defendant's misdirection. Because the defendant is the one who killed his son, Nathan, not mental illness. Please find the defendant guilty, because no matter how much bleach the defendant used to wash away his wrongdoing, it won't wash away the truth. Find the defendant guilty.
All right, thank you, counsel. Defense, do you want to open now, or do you want to wait until the beginning of, to midway point?
I'd like to open now, Your Honor.
Okay, whenever you're ready.
Evident, or may it please the court, counsel, members of the jury. Evidence, not emotion. That's what this case is about. You just heard a very emotional story from the prosecution detailing the horrible night that Timothy Ray killed his son, Nathan Ray, and his actions after that tragic incident. They showed you a picture of Nathan, but their story is based on emotion. And we ask that you pay attention to the evidence throughout this case, because the evidence will show that Mr. Ray, in the years, months, and even days leading up to October 17th, 2018, was suffering from a severe mental illness. Mr. Ray was neglected and abused as a child by his mother, who was later found to be suffering from a severe mental illness and institutionalized. Mr. Ray has been hearing and seeing things since he was 10 years old, with it coming and going for years at a time. But he suffered in silence, not telling anyone about what he was seeing or what he was hearing, because he was scared. Scared that he was going to end up like his mother, scared that he was going to be labeled mentally ill and potentially institutionalized. So you're going to hear that since he was 10 years old, he has continuously struggled with this mental illness, yet he attempted to live a normal life. He received a bachelor's degree from Skelton University, and shortly after, he enlisted in the military. But his ability to overcome the struggle with his mental illness didn't last long. And shortly after basic training, Mr. Ray was discharged from the military for mental health reasons. You're going to hear about his commanding officer who observed him having trouble with sleeping, having trouble with hallucinations, depressive thoughts, and even suicidal thoughts. But just like he was used to his whole life, he denied these observations because all he could think about was the troubling thought of being labeled mentally ill, the troubling thought of being potentially institutionalized. So for the next 8 years, he continued to struggle. He continued to hold on. And he began working as a computer technician at a small company. You are going to hear about an incident, and the evidence will show that he physically attacked an employee. You're going to hear from an expert in forensic psychiatry who's going to sit here and testify before you today that this is a sign of schizophrenia. But even more, he was found crying hysterically in his cubicle in the months leading up to October 17th, 2018. And as the months led up to that tragic night, he was all but losing the struggle to this internal mental illness, with the symptoms becoming more and more pronounced. You're going to hear about the negative thoughts and hallucinations and how they overcame him in the weeks leading up to October 17th, 2018, as he became more isolated, as he lacked hygiene, and he even neglected to sleep. That on October 17th, 2018, Nathan Ray spilled that juice on his laptop. Those voices finally overcame Mr. Ray. He was forced to do something unimaginable. He was forced to kill his son. But that is what brought us here today, members of the jury, because he is still suffering from that severe mental illness. And it is your job to determine whether he is legally responsible for the tragic incident on October 17th, 2018. The state has a burden to prove to you today. They have the burden to prove to beyond and to the exclusion of every reasonable doubt that this defendant is guilty of first-degree murder. But the evidences show that they're not going to be able to do that today. However, the prosecution is not the only party that walked into the courtroom today with a burden. The defendant pled not guilty by reason of insanity. And what this means is that we must prove by clear and convincing evidence that this defendant did not understand the wrongfulness of his actions on that tragic night. But this case is about evidence, not emotion. And to prove this, we are going to call two witnesses today. You're going to hear from Officer Wentz, the police officer who stopped Mr. Ray at the sobriety checkpoint. Now, Officer Wentz has extensive training in interacting and recognizing mental illnesses. And he's going to sit here today and tell you that Mr. Ray exhibited extreme paranoia during that sobriety checkpoint. And that he frantically was asking about the CIA on multiple times throughout that entire encounter. But he's also going to talk about his physical observations that night. He's going to talk about how she saw that he was disheveled. And he's acting strange to the point of doing jumping jacks in the middle of the road. But you're also going to hear from Major Shane Riley, an expert in forensic psychiatry, who analyzed the symptoms manifested by Mr. Ray throughout his entire life. Major Riley will tell you what are the signs that are associated with someone who suffers from schizophrenia. And they will sit here and testify to you today that Mr. Ray exhibited these symptoms when he saw hallucinations when he was 10 years old, up into the deterioration in his health in the weeks leading up to October 17th, 2018. But additionally, Major Riley will also testify to the negative effect that Mr. Ray's childhood abuse and neglect had on his mental health, and the effect that it had on Major Riley's subsequent opinion. Finally, Major Riley is going to talk to you about the possibility of malingering, or the ability to fake the symptoms, and how it's always a possibility at a criminal trial, but the evidence shows today that is not present here in this trial. At the end of this trial, my co-counsel, Alexandra McCormick, is going to show you and present to you all the evidence that we have seen today. We ask that you focus on the evidence, not emotion. And at the end of this trial, you're going to have to make a decision. And after you've heard all the testimony, after you have analyzed the facts, and once you have got a full picture, you are going to come to the conclusion that Mr. Ray should be found not guilty. A verdict, not based on emotion, but based on the evidence.
Thank you, counsel. Before the state calls its first witness, I'm going to ask everybody to switch to gallery view. That button should be in the upper right-hand corner of your screen, and that will allow you to see the attorneys and the witnesses that you need to see at the same time. So everybody needs to switch to gallery view if you're not already there. Got it. Okay. And if you guys give me just literally 1 second, I got to move this fan because it's blowing right in my eyes. Okay. State, call your first witness.
Your Honor, the prosecution calls Detective Booth to the stand.
Detective Booth, you are sworn.
Good morning, Detective.
Good morning.
I'd like to begin with what you do for a living.
I'm a detective here at the Skeleton Police Department, and I've worked here for about 23 years. I'm currently in the homicide unit, and that's how I became involved in today's case.
And how specifically did you become involved in the investigation on October 19th, 2018?
Well, I received a call from Officer Wentz that he'd apprehended Timothy Ray, who is the father and a suspect in the killing of Nathan Ray. I arrived and I saw that Mr. Ray was actually in handcuffs on the side of the road.
What happened next?
I went over to Mr. Ray and I let him know that we needed to take him in to ask him a couple of questions at the station. And then we left shortly after.
Before you got to the station, did the defendant mention anything at all about the CIA?
No, not at that time.
Did he seem to understand what was going on?
He did. In fact, he even said, "I understand, I'll tell you everything." And the way he said it, I believed him.
I'd like to direct your attention now to the interaction you had with him at the police station. Did you Miranda as the defendant?
I did.
And during this interview, did the defendant say anything about the CIA at that point?
At that point, he did. He asked me if I was with the CIA, and I told him no, that I was not, that I was a detective with the Skeleton Police Force.
Was the defendant's confession recorded?
It was recorded, and it was also preserved by transcript. I didn't preserve the audio and video of the recording because the system that we have at our police department actually erases that automatically after 30 days.
Let's talk more about the defendant's confession. What did you gather from the defendant's interview?
Well, the defendant confessed to me that he had killed his 6-year-old son and buried his body.
What was the defendant's demeanor like when he was telling you about killing his son?
Well, given that he was telling me about killing his own child, he was visibly upset.
According to the defendant, what happened on the morning of October 17th, 2018 first?
Mr. Ray said that he was getting ready to work on his laptop and that his son Nathan had just sat down for breakfast.
Was this taking place in Skeleton County?
It was.
Referring Court Counsel to what has been pre-marked as People's Exhibit 29 for identification. Detective Booth, do you recognize this photograph?
Yes, I do.
How do you recognize it?
That was the photo that was provided by Jessica Ray of young Nathan Ray when she filed his missing persons report.
And what is this a picture of?
It's a photo of Nathan Ray.
Is this a fair and accurate portrayal of Nathan as he appeared on October 2018?
It is.
Thank you, Detective Booth. Young people move prosecution exhibit 29 for identification into evidence.
Any objection?
No objection, Your Honor. However, we will object if they do leave it on the screen for too long and publish it to the jury.
Well, then that's fine. Make your objection at that time. So you may publish. It'll be received into evidence, and Mr. Simble, you may publish.
Thank you, Your Honor. Detective Booth, you mentioned earlier that Nathan was having breakfast. What was he eating that morning?
That morning, Nathan was actually eating his favorite cereal, Frosted Flakes, and he was actually drinking a glass of orange juice, or apple juice, excuse me, as well.
And what happened next?
Well, Nathan accidentally spilled that glass of juice onto the defendant's laptop. The defendant tried to turn on his laptop, but he stated that it was fried.
How did the defendant react to finding out that his laptop was fried?
Well, he said that he needed to punish Nathan for what he had done. He began yelling at the child, and Nathan got so upset that he started crying, and then he ran into his bedroom.
What did the defendant do after Nathan ran away?
He actually followed Nathan into the bedroom, and he continued to yell at him. And then he decided that he would make Nathan do jumping jacks and high knee exercises, and he wouldn't allow him to stop. But Nathan was crying so hard that he wasn't able to do the punishment, and the defendant just kept screaming at him. And Nathan eventually had to stop doing the exercises. He wasn't able to go on.
Objection, Your Honor. Just improper opinion. The fact that Detective Booth was not there and has lack of personal knowledge. They can attest to any fact that they received and had when Mr. Ray confessed. However, Detective Booth cannot act like they actually perceived the events that happened in this occurrence.
John?
Yeah. Yes.
I believe what the defense is objecting to is not improper opinion, but lack of or foundation or speculation. In this case, there is no the detective is just testifying to exactly what happened. He's not giving a lay or an expert opinion on what happened. He's just testifying exactly to what the defendant told him happened when he was in the interview room on October 19th.
That was my understanding as well. So I'm going to overrule the objection.
Detective Booth, what happened? How did the defendant react when Nathan stopped doing the punishment?
Mr. Ray decided that he had to punish him more to make him understand. So he went into his room and he stayed there for a few moments before he grabbed a belt from his closet.
And what did he do with the belt?
He returned to Nathan's room and he hit Nathan with the belt multiple times on his bottom. Nathan started to cry and he was screaming. He called out for his mother, but at the time, Jessica Ray was no longer living with Mr. Ray. And Nathan also said that he hated Mr. Ray.
What did we do next?
Objection, Your Honor, hearsay.
I'm sorry, I didn't hear the question. There was kind of a glitch. What was the question?
The question prior to this was, what did the defendant grab the belt for?
What did the defendant grab the belt for?
Correct, Your Honor.
And the objection is hearsay?
May I approach, Your Honor?
Yes.
Your Honor, it's not to the question. They elicited a statement from Nathan that said that he wanted his mother. That's going to be hearsay, Your Honor, and with no exception.
Your Honor, if I may be heard.
Yes.
We are using this evidence for the effect on the listener, so there is a non-hearsay purpose to it. We're not offering it for the truth of the fact that Nathan actually hated the defendant, but more so for how the defendant reacted after hearing that statement.
I'll overrule the objection. So Mr. Marcus, you did not have an objection to the question that Mr. Simbal had just asked.
No, Your Honor.
Got it. Okay. All right. So Mr. Simbal, you can continue.
Detective Booth, what happened next?
Well, the defendant decided to put the belt around Nathan's neck. And then he pulled the belt so tightly around his neck that Nathan struggled to breathe. He continued to hold it so tightly that Nathan couldn't breathe. He couldn't even let out a scream. And then Mr. Ray strangled Nathan with that belt.
Detective Booth, in investigating this killing, did you search any of the defendant's belongings?
Yes, we did. We conducted a search of Mr. Ray's phone. And at that time, we found 3 different items that he had searched that we used and were relevant in the investigation.
What were those 3 searches?
The first was countries that don't extradite for murder. Next was
Objection, Your Honor. This is the hearsay in our motion limine, if I may approach.
You may approach.
We would just like to renew and re-raise our motion that we brought to you before in the preliminary matters, Your Honor.
Okay. Mr. Simbal, what's your response?
Yes, Your Honor. Once again, these statements would fall under the hearsay exception of 801 D2 in that they are party opponent statement, the defendant's own searches, and thus his statements in the phone.
Mr. Marcus, do you have a response?
Yes, Your Honor. They said that they would provide foundation, yet there's lack of foundation. We don't know that the defendant actually searched these on his phone and that they were made by him. Therefore, it would be no exception to the hearsay rule.
Your Honor, the question I asked, Your Honor, the question I asked earlier was, did the defendant conduct any search of the defendant's belongings? So the response from the defendant, from Detective Booth suggests that yes, he did indeed search his belongings, and this is what he found, these particular searches.
Mr. Marcus, I'm going to overrule your objection. I'm going to allow you to cross this witness on your concerns about who conducted these searches, but they were found on the defendant's phone, so I'm going to allow it. Overruled.
Detective Booth, what were those 3 searches?
The first search was countries that don't extradite for murder. The next was how to get rid of a body. And the final one was, will bleach destroy a body?
What did the defendant do next after he had strangled Nathan?
After he killed his son, he placed Nathan's body inside of a trash bag, and then he buried him in a shallow grave at the Brandywine State Park.
Referring court counsel to what has been pre-marked as People's Exhibit 21 for identification.
I think we have the wrong picture here.
Exhibit 21.
There we go.
Detective Booth, do you recognize this photograph?
I do.
How do you recognize it?
My forensics team photographed and processed this scene when we were at the Brandywine State Park.
Your Honor, objection. Just to clarify, in their preliminary matters, they said that they would be showing the witness through this. I just want to make sure that this isn't being shown to the jury, Your Honor.
That is my understanding. Is that your understanding, Mr. Simbal?
Yes, Your Honor. For now, we're just laying the foundation. So if we may constructively show this outside the presence of the jury and
Yes,
proceed.
absolutely. That was my understanding. So thank you, Mr. Marcus, for clarifying that, but I think we're all on the same page. Okay, go.
Yeah. How do you recognize this photograph?
My forensics team photographed and processed this scene while we were at the Brandywine State Park.
And what is this a photograph of?
It's a photo of Nathan Ray's body inside of this trash bag. It's buried in the shallow grave, and you can actually see Nathan's tennis shoe on the bottom left portion of the video, or the photo.
Is this a fair and accurate portrayal of the crime scene is on the day that you investigated it?
Yes, it is.
Now, at this time, the prosecution moves Exhibit 21 into evidence.
Any objection from you, Mr. Marcus?
No objection, Your Honor.
It will be received and you may publish if you wish.
Thank you, Your Honor. Detective Booth, do you see the person who did this to Nathan in the courtroom?
Yes, I do.
Could you please point them out?
He's on this Zoom call sitting next to the counsel.
Let the record reflect the witness has identified the defendant. No further questions.
It will so reflect.
No further questions, Your Honor.
Oh, great. Okay. All right. Do you wish to cross-examine, Mr. Marcus?
Yes, I do, Your Honor.
You may proceed when you're ready.
Detective Booth, you've been an officer for about 23 years.
That's correct.
But before working in the homicide department, your previous investigations were conducting the gang and narcotic department.
Yes,
Now, this case was the 12th case that you've investigated.
that's correct.
But you haven't led all 12 investigations, have you?
No, it's normal for you to sort of rise in the ranks, and I've been leading multiple investigations before this. This is actually my fourth.
So this is your fourth time leading a homicide investigation.
Yes, that's what I said.
Now, I want to walk through the night that Mr. Ray confessed. You responded to a call that Mr. Ray had been apprehended.
Yes,
You took him down to the station for questioning.
that's correct.
And this interview was recorded.
Yes, it was.
You didn't observe any odd behavior during the interview.
As I stated on direct, I did observe that Mr. Ray stated that he asked if I was with the CIA. At that time, I reminded him that I was in fact with Skeleton Police Department and that I was the detective there.
If you don't mind, just be helpful to the court reporter. Would that be a yes or a no?
Yes, I did observe odd behavior in him stating that he was with the CIA.
You knew Mr. Ray before that interview,
I did. Our sons played soccer together.
and you frequently saw him at soccer games.
At the practices, yes.
You talked with him.
Occasionally, yes.
You noted he was socially awkward.
He could be, yes.
He was.
Yes.
And he lacked hygiene.
Yes, he seemed a little dirty.
So he lacked hygiene.
Yes.
And during this interview, Mr. Ray was unable to remember who you were.
He didn't seem to, no.
You reminded actually repeatedly of your position as a skeleton police officer, detective at the PD,
Yes, I did.
but he asked you multiple times if you were CIA.
Yes, that's what I said previously.
But you did not believe there to be a mental health issue.
No, it's frequent that if someone's trying to hide something, they might act like they have a different mental state. And that's what I believe was occurring at the time.
Now, Mr. Ray confessed, right?
He did, of
And at the end of this interview, the recording stops.
course.
It's automatically saved.
Yes, our system preserves it for 30 days.
And you requested a transcript of the interview,
Yes, I did, and we have that transcript today.
but not the audio or video recording.
No, like I stated, the system automatically erases the videos after 30 days. I preserved the transcript, but the video was automatically erased after that time.
But you could have preserved the copy,
I could have, but in this case, I chose to preserve the transcript.
but you didn't.
I didn't preserve the video, no.
Now, you complete an incident report, right?
Yes, I did,
And as an officer, you're trained on how to fill out an incident report.
of course,
It's got to be accurate,
of course.
complete,
Yes,
truthful.
yes,
It's got to be thorough because you have to rely on it in the investigation and if it needs to be brought up by prosecution, right?
yes, that's correct.
Yet this incident report that you wrote was a total of 8 lines.
It was a one-page report, yes.
So is that a yes to my question? It was a total of 8 lines.
It was 1 page, yes.
I mean, I'm going to ask you a question again. I mean, my question was, you wrote an incident report and it was a total of 8 lines, narrative portion.
In the narrative portion, yes.
Now, you didn't include any observations of Mr. Ray's behavior?
No,
Never that he mentioned the CIA?
not on that report, no.
And you look no further into Mr. Ray's mental condition after he confessed?
I had interviewed the witness or Mr. Ray, and I had been able to experience his mental state at that time.
You look no further into Mr. Ray's mental condition after Officer Wentz expressed concern?
No further than the interview that I conducted with him, no.
You received mental health training,
I did.
but you can't remember any specifics of that training?
No, I received that training about 20 years ago, and so I can't remember the specific details of it.
Now, I just want to talk about something that you talked about on direct, the defendant's phone searches. You have no personal knowledge of the defendant making those phone searches, do you?
No, but that phone was found to be Mr. Ray's phone. It was in his possession, and we have no evidence that anyone else would have used his phone or searched those specific things, especially considering the fact that Mr. Ray was the suspect in the crime in which those searches were related to.
But you have no personal knowledge of the defendant actually making those phone searches?
Other than it being his specific phone that we found on him, no.
No further question at this time, Your Honor.
Okay.
Moment to
Any-
confer, or it's actually fine.
Oh, okay. Any further questions, Mr. Simbal?
No, Your Honor.
All right. May the witness be excused.
Yes. And my co-counsel will call the next prosecution witness.
Your Honor, the prosecution calls Dr. McLagreca to the stand.
Dr. LaGreca?
Good morning, Dr. LaGreca.
Good morning.
Wait, we need to stop just a minute. Please stop the timing. I do not see the questioning attorney on my screen. There we go. Okay. All right. You may continue, Ms. Jackson.
Thank you, Your Honor. Dr. LaGreca, what do you do for a living?
I'm a forensic psychiatrist.
What is a forensic psychiatrist?
Well, psychiatrists in general, we specialize in seeing and treating mental health patients. Forensic psychiatrists, I just specialize in how mental health relates with the law. So that includes consulting attorneys, providing expert witnesses, and consulting with law enforcement.
Have you come here today to give an opinion regarding Timothy Ray's mental health the day that he killed his son, Nathan Ray?
Yes, I have.
We'll get to your opinion in a moment. But first, I'd like to talk a bit more about where you completed your degree to become a forensic psychiatrist. Can you provide us with some context?
Yeah, let's see. I got my bachelor's degree in chemistry at University of Delaware. I went on to get my MD from UPenn, and I completed my residency in psychiatry out in California at UCLA. And then I came back to UPenn to do a fellowship in forensic psychiatry.
And after completing your education, where did you practice? What did you do for practice?
For practice, I went into private practice for 2+ decades. I work with a diverse patient population. So I was diagnosing and treating a wide variety of mental illnesses, including schizophrenia.
Where do you work now?
Now I'm a program director at the local medical school.
Do you still treat patients?
Yeah, once a week at Jamie Spears Hospital.
Your Honor, prosecution tenders Dr. McLagreca as an expert of psychiatry.
Any objection?
Yes, Your Honor, may we approach?
Yes.
Your Honor, we would object to the tendering of this witness as an expert under Federal Rules of Evidence 702, expert witness testimony. We would ask to have the opportunity to voir dire the witness outside the presence of the jury at this time.
Any response, Ms. Jackson?
No, Your Honor, no objection.
Okay. And just to make sure the timekeeper understands that the voir dire counts toward the defense counsel's time and not the prosecution team's time. So with that, Ms. McCormick, you may do your voir dire.
Dr. LaGreca, you said you sold your private practice back in 2017.
Correct.
Now you're treating patients just once a week.
Yeah, in the context of being program director at the medical school.
You've been a psychiatrist, though, for about 26 years.
Yes.
During that time, you've never been published in schizophrenia, have you?
Now enter. Please make your way to the exit.
Sorry, Counsel,
Thank
could you
you.
repeat the question, please?
During your time, you've never been published in schizophrenia.
No, I mean, publishing is in an academic setting. I've been practicing privately for that long.
So you've also never been published in psychiatry.
No, not in the academic sense. I have not.
Well, Dr. LaGreca, you've never been published in anything at all, have you?
That is correct, Counsel, but I've been a psychiatrist for 20 plus years.
You are currently working on a study, though, is that correct?
That is correct. We're in the finishing touches of that.
That study is on malingering,
Yes, that is correct.
specifically when it comes to subjects facing serious punishment.
Yes, that is correct.
You have not been able to complete this study, though, have you?
We have preliminary results. It's just finishing up its last touches.
But you're still collecting the necessary data that you would need?
Yes, I am.
And this study is one of the materials that you relied upon in order to form your opinion in today's trial.
That plus my 20 plus years of experience, yes.
You've also mentioned that you testified before, correct?
That is correct, yes, a handful of times.
But you've only testified under oath in 2 cases.
That is correct.
Both cases regarding issue of dementia.
Yes,
You have never testified in cases dealing of schizophrenia.
yes, but I have treated plenty of patients with schizophrenia and other mental health disorders.
But you would agree that you have never testified in the court in cases dealing with schizophrenia.
That is correct.
A moment to confer, Your Honor.
Certainly.
Your Honor, pursuant to Federal Rules of Evidence 702, expert witness testimony, we would object to Dr. LaGreca being tendered as an expert witness in this trial. The prosecution has attempted to declare his expertise in forensic psychiatry. However, the witness has just testified that they lack practical experience, only treating patients just once a week. The witness has also testified to issues related only to dementia, not schizophrenia, which is what we are here for today. But most importantly, Federal Rules of Evidence 702C requires that the testimony be product of reliable principles and methods. The witness relied upon a study that is incomplete. The study has also never been peer-reviewed, field tested, nor has it been published. And for those reasons, we would object to him being tendered as an expert witness in this trial.
Ms. Jackson, do you have a response? And just so you know, you've disappeared from my screen. Got it. Okay.
Yes, Your Honor, I do have a response. May I be heard?
Yes.
As Dr. LaGreca stated earlier, he has over 20 years of experience dealing with psychiatric patients in that format, in that setting. Although his study of over malingering and the connection with criminal prosecution has not been published yet, Dr. LaGreca is not basing his entire opinion on that one study, Your Honor. It was just to support or bolster his argument. Dr. LaGreca has reviewed over 25 hours of medical history and reports given to Major Riley, which the defense relies on as well, Your Honor. And with that, he has been able to form his opinion based on his 20 years of experience and the information that the defense is forming their opinion on as well. So we would like to argue against Dr. LaGreca not being tendered. He should be tendered. He has well enough experience to be able to sit in front of a jury to clearly explain why the defendant, his opinion regarding the defendant's actions on the day that he killed Nathan Ray.
I agree, and I'm going to overrule the objection. And Dr. LaGreca will be received as an expert.
Thank you, Your Honor. Now, Dr. LaGreca, can you share with us your first opinion after reviewing the defendant's evaluations and diagnoses?
Well, my opinion, to a reasonable degree of medical certainty, and based on all the documents I've been able to review, is that in this case, on October 17th, 2018, Mr. Ray did not suffer from severe schizophrenia.
How did you arrive at that conclusion?
Well, I have three main reasons.
What are those reasons?
The first reason being that he's not had a previous diagnosis or under his evaluations that he suffered from schizophrenia. The second reason I have is that once he committed the crime, he began showing signs consistent with malingering. And then finally, the manner in which he killed his son, Nathan Ray, to me showed he wasn't suffering from schizophrenia.
Your Honor, may we have permission to publish for demonstrative purposes regarding Mr. LaGreca's opinion?
Can you say that again?
Yes, may we have permission to publish a demonstrative to lay the proper foundation for Mr. LaGreca's opinion?
Any objection?
No objection, Your Honor.
Yes, you may.
Now, Mr. LaGreca, now to your first point regarding the defendant's diagnosis and evaluation. How did you arrive at this conclusion that he never suffered schizophrenia?
Well, back in 2010, according to Dr. Riley's full and complete psych eval, he had diagnosed Mr. Ray with general anxiety disorder, and he treated him subsequently for that. And then he discharged him afterwards, pretty much because he wasn't in danger to himself.
Was he ever diagnosed with schizophrenia?
No.
What happened after Dr. Riley diagnosed the defendant with general anxiety disorder?
Well, afterwards, Dr. Riley suggested for Mr. Ray to follow up and see a therapist, and as well as his PCP, Dr. DiGiuseppe.
Did Dr. DiGiuseppe ever diagnose Mr. Ray with a mental disorder?
No, Dr. DiGiuseppe never diagnosed Mr. Ray with a mental disorder in any form, for that matter.
Why is this important to your opinion?
Well, he's never been diagnosed with or treated for schizophrenia. On the contrary, he was diagnosed for generalized anxiety disorder and depression. And on top of that, Mr. Ray never really sought any treatment from any mental health professional leading up to the day in question.
Now, let's move on to your second opinion regarding the defendant's symptoms as they were consistent with malingering. But first, can you tell us what malingering is?
Malingering is when someone's faking or exaggerating symptoms of an illness in order to avoid punishment and to create a legal defense.
Why did you conclude that the defendant was malingering?
Well, based off of the materials I reviewed, Mr. Ray showed 3 of the 4 DSM-5 symptoms for malingering.
What is the DSM-5?
The DSM-5 is the 5th manual or handbook we healthcare professionals use. It has descriptions, symptoms, and criteria for diagnosing different mental disorders.
Referring court and counsel to what has been pre-marked as Exhibit 17A, Your Honor, may we publish 17A outside of the presence of the jury to lay proper foundation?
Yes, and you don't need to ask. I think we can all agree that when you publish something, when you're laying the foundation, that that this is outside the presence of the jury. I did rule. Okay.
Dr. LaGreca, do you recognize what's on your screen?
Yes, I do.
What is it?
It's just an excerpt from the DSM-5.
How do you recognize what's on your screen?
Just from preparing my report for the case.
Is this an accurate depiction of the DSM-5 that you used to prepare your report?
Yes, it is.
We move into evidence 17A.
Any objection?
No objection, Your Honor.
It'll be received.
Now, Dr. LaGreca, what symptoms of malingering did you observe after your review?
Yeah, so you have to look at the context first. So Dr. Riley's assessment occurred in the context of a criminal evaluation. So that in itself is incentive for Mr. Ray to fake symptoms to avoid taking responsibility or being punished.
Is it your expert opinion that the defendant was faking symptoms?
It is. There are several things he showed for the first time ever after committing this crime. Discrepancies like that are definitely a hallmark sign of malingering.
What were the discrepancies you noted in your report of the defendant's history?
The first discrepancy was Mr. Ray not having any mention of suicidal thoughts, and then during the interview, he was saying that he was having all these suicidal thoughts for years.
What else?
He also mentioned things about visual hallucinations, so triangles changing shapes and colors, and even hearing voices.
How so?
Well, he started by lying to law enforcement about his ID as well. But once they found his ID, and they were about to figure out who he was, he started exaggerating some other symptoms.
Is there anything else worth mentioning?
Well, I guess to just within the context of it all, he never experienced all the symptoms you would think a schizophrenic would experience at the same time. So, in that sense, that seems very much more like malingering.
Is there anything else?
Yeah, I would say when he was stopped at the sobriety checkpoint, that's when he was showing those exaggerated symptoms like rambling, doing jumping jacks, yelling things. We in the medical community don't like calling it crazy, but to an untrained eye, it does seem abnormal.
Is there anything else worth mentioning regarding the defendant's behavior?
Yeah, just that. Yeah, just that. Within this whole context, it's definitely um, leaning towards malingering, just because of the incentives,
Incentives like what?
like evading a criminal prosecution.
Now, Dr. LaGreca, can you tell us what your third main reason was that led to your opinion?
Yeah, that would be like I mentioned before, the manner in which he killed Nathan Ray. He made a conscious choice. So first, the conscious decision was to punish Nathan, right? And then he went to his bedroom, he calmed down, and then he went to grab a belt and strangle his son.
Why is this important to your opinion?
Well, it's not like it was a split second decision. He wasn't acting out of some passionate crime or anything. He calmed down and then he grabbed the belt and then he hit Nathan Ray, punishing him in his terms, and then he tries to get away with it by hiding evidence.
Now, you mentioned the term punish a few times. Can you explain why that is important to your report in a hypothetical sense?
No, well, when someone punishes someone else, that's because in that person's mind, the other person has done something right, done something wrong, rather. Um, so, and also, when you try to hide evidence, you think what you did in itself was wrong.
Is this hypothetical theory consistent with things that the defendant might have done after he killed Nathan Ray?
Yes, I believe so.
How so?
Well, the fact that of the matter is, after he killed Nathan Ray, he tried to hide the evidence. He searches how to get away with killing his child. He carried through with it, and he wrapped his 6-year-old in a bag and threw him in the car, and then buried him in Brandywine State Park.
No further questions, Your Honor.
Ms. McCormick, do you wish to cross-examine?
Yes, I do, Your Honor.
All right, whenever you're ready.
Dr. LaGreca, the state is paying you to be here.
Yes, like any expert witness, I get a flat fee and an hourly rate.
You make about $500 an hour just to review materials.
Yes.
And you're making $1,750 just to testify about those materials today.
Yeah, you have to factor in my travel time and all the other nuts and bolts that come up with the budget. But yes, that's correct.
Like your lodging and meals.
Yes,
You previously stated that you are a teacher, correct?
that is correct.
You have not published a study on schizophrenia during that time.
No, I have not.
You have not published a study on malingering during that time.
Not at the moment, correct.
In fact, you've never been published during your past 26 years.
That's correct, but that's because I've been treating patients with all sorts of mental health disorders. I recently just switched over from private practice to academia counsel.
You have testified before, though.
Yes, I have.
Never to schizophrenia?
Sorry, counsel, could you repeat the question?
You've never testified to the issue of schizophrenia, have you, Dr. LaGreca?
No, I have not.
And you've never testified to the issue of malingering.
No, I have not.
You mentioned earlier that you were working on a study, though, about malingering.
Yes.
You used the study to aid in your evaluation of Mr. Ray?
No, I think the study supports it, but I just use my clinical expertise for the past 25 years and reviewing the case materials provided.
The study that you have been working on, that you have used to rely on, in addition to all the other materials.
Objection, Your Honor.
Yes?
Her questions are asked and answered. These questions have been, my expert has asked and answered these same questions during the voir dire and previously in this cross.
Overruled. The voir dire was not in front of the presence of the jury, so she's allowed to re-ask the questions here. And I haven't really heard her repeat that much, so Ms. McCormick, you may go on.
Dr. LaGreca, I'm asking you a simple question. The study that you are in the midst of conducting is part of your evaluation to form your opinion in today's trial, is it not?
Well, I think that's a little difficult to answer. I think it speaks to it certainly, but I don't, if I hadn't published or if I have not been in the works of publishing the article, I think I would have come to the same conclusion.
So let's talk about what you absolutely did use to form your opinion. On direct examination, you spoke about your opinion that Mr. Ray is malingering.
Yes.
You relied on Major Riley's report to form this opinion.
Yes, I did, as well as the DSM.
And in Major Riley's report, it includes that the United States Army reported that Mr. Ray had been seeing things back in 2010.
Well, correct, but the thing is, when Mr. Riley observed him in a clinical setting back in 2010, he denied those things.
But it was still reported by the United States Army that he was seeing things, correct?
Objection, Your Honor.
What are the grounds for your objection, Ms. Jackson?
Hearsay.
Ms. McCormick, will you re-ask the question? Just for my
Yes, Your Honor.
yeah.
I asked whether the United States Army reported that Mr. Ray had been seeing things back in 2010. This is part of Major Riley's report.
Overruled.
Let's talk about what else you read in that report, Dr. LaGreca. That Mr. Ray would lock himself in the bathroom for several hours.
Yes. Did you want me to confirm that or?
Yes.
Yeah, that was in the report.
That his own mother suffered from severe mood swings?
Yes, that was in the report.
That he attacked a coworker?
Yes.
That on the night that he was arrested, he was disheveled.
Yeah, well, I'd imagine if in the context of murdering his son, he wouldn't be in the best, position.
But all of this occurred before the arrest.
Yes, well, the thing is, the different mood swings could indicate a variety of different mental disorders or mental behaviors. So it's a little hard to, you know, sort of understand. I feel like I have to look at the context, you know.
Dr. LaGreca,
hmm
let's talk about what else you relied on in this case.
Okay.
You relied on the transcripts of the law enforcement interviews.
Yes.
They included the transcripts between Officer Wentz and his interview with Detective Booth.
Correct.
That's where you learned Mr. Ray asked if Officer Wentz was with the CIA.
Correct.
He asked that question more than once, didn't he?
He did, and that was while he was being arrested, I believe.
So the answer is yes to that question.
Yes.
He asked Officer Wentz more than once, didn't he?
Yes.
Officer Wentz also observed strange behavior.
Correct.
He even expected an EMT to arrive on scene.
I believe so. Yes.
You also relied on the transcripts of Detective Booth's interview with Mr. Ray.
Yes, I did.
He asked Detective Booth if he was working with the CIA as well. Isn't that correct?
That's correct. That's after he admitted to committing murder.
And yet your opinion in this case is that Mr. Ray is malingering?
Yeah, it's not the fact that he's displayed abnormal behavior. It's the context in which he did it. So Mr. Ray, in my medical opinion, only did it when he was, in essence, about to be caught or for the crime.
And you based this decision off of the DSM-5 as well as the other transcripts and information that you were gathered.
Yes.
The DSM-5 definition of schizophrenia includes that symptoms can emerge between the ages of mid-teens to mid-30s.
Correct.
And it also says that only 19% of people are malingering.
Well, it said, I believe it's a likelihood, but yes, yes.
Just to clarify, Dr. LaGreca,
Mhm.
only 19% of people are found to be malingering in serious cases.
Correct.
Cases such as this one,
Yes.
which would leave 81% of people not faking their symptoms.
Well, I would say it would lead to 81% of the likelihood. So we can't, I think it's hard to use statistics to equate conclusions, so to speak. The likelihood has to be seen in the context of the investigation.
Dr. LaGreca, it's a simple question.
Mhm.
We could agree 81% of people do not malinger.
I would say most likely, yes.
A moment to confer, Your Honor.
Yes.
No further questions.
Ms. Jackson, do you have any redirect? Oh, Ms. Jackson, you disappeared. There we go. Okay.
I have one question for Mr. Dr. LaGreca.
Whenever you're ready.
Dr. LaGreca, outside of the report of the malingering study, does the 19% affect your opinion regarding schizophrenia?
Well, no, it doesn't affect my opinion. I think that when it comes to schizophrenia, you have to see the progression, and instead we see acute events within the context of a criminal investigation. So while it is true that there's a 19% chance of one to malinger or 81% to not be malingering. And within the context of this case, it seems to be malingering.
Thank you. No further questions, Your Honor.
Any further witnesses from the prosecution?
No, Your Honor.
Not at this time, but the prosecution would like to read in a few stipulations for the record, though.
All right, go ahead. Have you conferred with, well, there's stipulations, right? So you go ahead.
Yes, Your Honor. The people move to admit the autopsy report, Exhibit 6, missing person report, Exhibit 7, and prison medical records exhibit 8 as admissible per stipulation 4.
Hearing no objection, they'll be received.
Thank you, Your Honor. Prosecution rests.
Shall we take our break now?
Your Honor, just I guess before, may I make a motion?
Yes, you may.
Your Honor, pursuant to Federal Rules of Criminal Procedure 29A, the defense moves for a motion of judgment of acquittal. And when viewing the evidence in a light most favorable to the non-moving party, in this case, the state has failed to prove a prima facie case specifically as to first-degree murder that a reasonable jury could find for them. With this, the defendant is charged with first-degree murder, Your Honor, and they must prove premeditation, and that it has to be caused with malice aforethought. Now, they may prove premeditation with 3 things: the consideration to kill, the decision to kill, and the killing arising from that period of reflection. The state did not establish that these sequence of events, and they cannot establish that the alleged person killed was with malice aforethought.
Mr. Simbal, I want to hear your argument, but first, may your witness, Dr. LaGreca, be excused, because he's still here on the screen. All right, thank you for your testimony, Dr. LaGreca. Mr. Simbal, how do you respond to the prosecution's argument?
Yes, Your Honor. Well, at this point, Your Honor, the prosecution has shown that the defendant was malingering, that the defendant did show different symptoms of trying to fake schizophrenia, but he had many incentives to do so, and that ultimately he was not suffering from any of those delusions or hallucinations that he reported. We've also shown that he did indeed commit the crime, that he did indeed kill his son. And it is my understanding that for a mid-trial motion like this, the burden is a preponderance of the evidence. And we have more than satisfied that burden through the evidence that we have shown thus far, that again conclusively shows that the defendant is responsible for his actions and is trying to escape responsibility by faking symptoms of schizophrenia.
If I may, Your Honor. Your Honor, no one's here is arguing the fact that this defendant killed his son. However, they have the burden to prove beyond a reasonable doubt that he killed his son with premeditation. The definition that this court uses is a period of to kill over a period of reflection, and they have not shown that or proved that today.
Can you show me tell me the jury instruction that you're referring to, Mr. Marcus?
Yes, Your Honor. Give me 1 sec, Your Honor.
And it is my understanding that the Rule 29 is not timed. You guys understanding as well?
Yes, Your Honor.
Okay, so let me know what jury instruction you're referring to.
Yes, Your Honor. That is going to be in the jury instructions on page 9, or actually, yes, on page 9 or 10, actually, or 8. Sorry, Your Honor. I'm flipping through my pages. Page 8, Your Honor.
All right, Mr. Sembal, how do you respond to that argument?
Yes, Your Honor. Once again, we've not only shown that the defendant is responsible for the killing, but that this indeed was a murder, that he did act intentionally, that he did act with malice aforethought. This was exhibited by the fact that he remained in his room for a moment and reflected, as we heard from Detective Booth and as Dr. LaGreca presented testimony, showing that he ultimately did have a period of premeditation. This suffices, as the law states in the jury instructions, that for there to be a moment of premeditation or a reflection, it only needs to be a few seconds. And that's exactly what we have in this case when the defendant left into his own bedroom to reflect.
I agree. The motion will be denied. So let's take a 10-minute break so that everybody can get a drink of water and use the facilities and confer with counsel and all of that. And when we get back, so 10-minute break. So we're going to come back at, let's say, 9:40. Okay. Thank you very much.
Your Honor, the timekeepers have conferred. We would like to put the times on the record, if that's possible.
Yes, I would like that as well. I just want to make sure that the advocates, they may have run to the restroom. So can we put the time? So can that be what we start with when we come back from our break? I just want to make sure that everyone is in the room and can hear it. Thank you very much for reminding me. All right. Do we have our jurors back? We're a couple minutes early. Just want to make sure that we've got our jurors back. We have present juror Padilla. Let me just check, advocates, let me just check that we've got our jurors back. While we're waiting for this, why don't the timekeepers come on screen and let us have the time check they were talking about.
So we've conferred and prosecution has 28 minutes, 45 seconds remaining. And defense has 33 minutes, 38 seconds remaining.
What was
So
the,
stipulated.
say the defense again, 33 what?
33 minutes, 38 seconds.
All right.
So stipulated, Your Honor.
Fantastic. All right. Thank you much. I need juror. All right. I'm looking for juror. I've got juror Padilla. I need juror McCoy. And
McCoy is here.
And juror DiGiuseppe, are you there?
Yep.
Great. All right. Whenever you are ready, defense, you can call your first witness.
Defense would call Officer Wentz. May I inquire?
Yes, I think there might be too many people. There we go. Yes, you may inquire.
Good morning. Could you please state your name for the record?
Hello, my name is Peyton Wentz.
What do you do for a living?
I'm a police officer with the Skeleton Police Department.
How long have you been an officer for?
It's been about 4 years now.
Before becoming an officer, did you go to school?
I did. I got my bachelor's degree in criminal justice. And then after I graduated, I joined the academy and did some training while in the academy.
Did you have any specialized training?
Yes, part of the program was a specialized training program called the Crisis Intervention Training Program. It focused on mental health type issues.
How long did it take to complete this training?
That course was a 40-hour program. It covered things such as de-escalation training for us on interacting with people with mental health issues and such as schizophrenia and psychosis.
Officer Wentz, I want to talk a little bit about why we're here today. How did you become involved in this case?
I was working the sobriety checkpoint training that I always did, and I was the one who interacted with the defendant on October 19th of 2018.
I'd like you to walk me through that evening. So let's start with what you noticed once you made contact with Mr. Ray. Could you describe what he looked like?
Yeah, so when his car pulled up to the checkpoint, I signaled to him to roll down his window, and I observed that he looked disheveled, his hair was a mess, his eyes were glassy, there were stains all over his shirt, and the car just appeared to be a mess.
After making those observations, what did you decide to do?
I had Mr. Ray pull over to the side of the checkpoint.
What happened after that?
I asked for his license and registration like I do with every routine traffic stop.
What did you do once you had this information?
I brought it back to my partner so that he could run the information, and then I went back to the defendant's car.
As you arrived at the defendant's car, what happened next?
I approached the driver's side window and he started yelling, asking me if I was with the CIA.
Officer Wentz, are you with the CIA?
No, I'm not. I'm just a skeleton police officer.
Is that all Mr. Ray asked you?
No, he also said that he could hear the sirens coming to get him.
Officer Wentz, were there any sirens that evening?
No, we had our lights on our cars, but there were no sirens.
So how did you respond to Mr. Ray?
I showed him my badge. I was in my uniform, and I, just wanted to assure him that I was a skeleton police officer. I wasn't with the CIA, but he kept asking me whether I was with the CIA.
And at that point, what happened?
I finally asked him to step out of the vehicle, and after I assured him multiple times, he finally did.
So let's talk about what happened once he was out of the vehicle. Could you describe your observation of Mr. Ray at that time?
Yes. So when he was finally able to step out of the vehicle, his demeanor changed almost immediately.
Could you describe that change?
Yes. So as he was stepping out of the vehicle, he had a blank stare on his face. He stopped making eye contact with me and started to act like a zombie. He just kind of went completely blank.
Did this continue for long?
No. Shortly after that, he started to do jumping jacks.
Officer Wentz, what did you do at this point?
I tried to get him to stop doing the jumping jacks, but he wouldn't right away.
Were you eventually able to stop him?
Only once I pulled my gun and had to threaten him before he stopped doing the exercises.
What happened after that?
Once he stopped doing the jumping jacks, he started to move his head around and hold his hands over his ears as if he were like a little kid trying to stop hearing something.
Officer Wentz, would you mind demonstrating to the jury what exactly he was doing?
Sure. So he had his hands over his ears like this, and he was shaking his head like really just violently.
Thank you, Officer Wentz. Did he eventually stop?
Yes, eventually I was able to grab one of his arms and handcuff him and detain him.
But at this point, was Mr. Ray under arrest?
No, we were just detaining him at that point.
So what happened after you had handcuffed him?
I went to check in with my partner and sat Mr. Ray on the curb a couple feet away from our patrol car.
What did you learn once you were able to talk to your partner?
I learned that Mr. Ray's plates were flagged for a missing persons investigation filed the day before about a little boy. I had my partner keep an eye on Mr. Ray while I went to call it into the station.
So you've called what you found into the station. What happened next?
Shortly after I called it in, Detective Booth from the Homicide Division responded to the call.
Were you expecting anyone different?
Yes, I was surprised that they didn't send an EMT.
Why did that surprise you?
Well, based on what I had reported when I made the call into the station about the defendant's behavior, I suspected that they would send an EMT, but they didn't.
Once Detective Booth arrived, did you leave the checkpoint?
Yes, once Detective Booth arrived, he had me and my partner transport Mr. Ray to the station to be interviewed by Detective Booth.
So let's focus now on that drive into the station. What did you notice during that time?
He was pretty calmer at that point, other than what I had observed just moments before. He just seemed to be talking to himself in the back of the vehicle.
So once you arrived at the station, how did Mr. Ray act once you were there?
He was a lot calmer and quieter, pretty much the same as he was in the car. He was cooperative, and I put him into the interview room, and he started to cry and just put his head down on the table until Detective Booth came in to interview him.
Officer Wentz, did you sit in for the interview?
No, I did not.
Did you happen to have any further involvement in the case?
No, once I put him in the interview room, I left, and that was the last of my involvement in the case.
A moment to confer, Your Honor. No further questions at this time.
All right, Ms. Jackson, do you wish to cross-examine?
Yes, I do, Your Honor.
You may proceed when ready.
Officer Wentz, I'd like to talk about your interaction with the defendant on October 19th, 2018.
Okay.
You were the first person to come into contact with the defendant after he killed his son, weren't you?
At the time, I didn't know he killed his son, but yes, I did stop him at the traffic checkpoint that night.
Yeah, you were the first person to stop him at the sobriety check. And when you approached the vehicle, you noticed the car was a mess, didn't you?
Yes.
The defendant had trash bags in the back seat
Yes.
and a dirty shovel right next to it.
Yes.
What looked like blood on it.
Yes, I wasn't really able to tell, but it was a red substance.
Yeah, and you also noticed his behavior. He was a bit antsy.
Yes.
And all of that stuff in the back seat raised a red flag for you, didn't it?
Mostly his behavior and how strange he was acting, but yes, that coupled with all of it did.
So your next step was to identify Mr. Ray. Isn't that correct?
Yes,
So you asked for his driver's license
I did.
and registration?
I did.
And we all know the standard protocol at a stop is to ask for those things, but Mr. Ray tried to avoid handing you his identification, didn't he?
He did at first, but eventually I did get it.
Yeah, he lied to you, didn't he?
Yes, he tried to tell me that he didn't have them. However, I did see them on the seat next to him, and then I was able to obtain both the license and registration.
Yeah, in fact, he told you that his wallet was at home with the driver's license inside of it at first. Isn't that correct?
I think that's what he said, yes.
Yeah, and when you took his identification, you brought it back to your partner to run his identification. Isn't that correct?
Yes.
But you returned back to the defendant because you were concerned about his behavior.
Yes, he was acting extremely, I would just say off.
Yeah, things changed when you returned to his vehicle, right?
Yes, he started asking me if I was the CIA.
He at one point, he even yelled at you.
If I was the CIA, yes.
And let me get this right. There was a point where the defendant was doing jumping jacks in the middle of the road.
Yes, it was totally crazy.
In fact, possibly unreal that he was exhibiting so many different behaviors within a short period of time.
Sorry, I didn't understand your question. Can you re-ask that, please?
It was strange that the defendant was behaving in this way, wasn't it?
Very strange.
So let me get this straight. When you first approached his vehicle initially, he wasn't asking you crazy questions, was he?
No,
He said absolutely nothing about the CIA.
not until I started to talk to him now.
Yeah, and initially, he didn't even yell at you from his car, did he?
No, he just pulled up to the checkpoint.
And he definitely wasn't doing jumping jacks, right?
No, he was in his car.
All of those behaviors happened after you returned, after you had his ID, correct?
Yes.
Now, I want to be clear about one more thing. It wasn't until you began to check the defendant's ID that he started exhibiting all of these random behaviors.
Yes.
No further questions, Your Honor.
Ms. McCormick, any redirect?
Yes, Your Honor. Officer Wentz, who conducted the search of the information of Mr. Ray?
My partner.
And after that, you noticed that he was acting strangely?
Yes, he was acting extremely paranoid and just exhibited behaviors that I thought needed to be reported to the station.
And because of that, what did you do?
I
Or what
called
did
it.
you expect? I'm sorry.
I expected an EMT because of his odd behavior.
No further questions, Your Honor.
All right, may the witness be excused?
Yes.
You may be excused. Thank you, Ms. Officer Wentz. Does the defense have any further witnesses?
Yes, Your Honor. We'd like to call Major Riley.
Please do. Major Riley, you are sworn. I think I've sworn everybody, haven't I?
Yes, Your Honor.
You may proceed when ready.
Would you please introduce yourself to the jury?
My name is Major Shane Wiley.
And what do you do for a living, Major Shane Riley?
I'm a military veteran, and I'm also a military forensic psychiatrist.
What does someone do as a military forensic psychiatrist?
This particular field of medicine that I practice is a mix of psychiatry, the law, and the military.
Is there any schooling or training required to become a psychiatrist?
Yes, I had to complete several years of school and medical and clinical experience.
What schooling did you complete?
I received my BA in biology from Notre Dame in 1993. I then attended a uniform service University School of Medicine, where I received my MD degree in 1997. I decided to enter my class as a commissioned officer in the US Army, and I graduated fourth in my class.
And when did you complete your psychiatric training residency after this?
After graduation, I completed a 4-year psychiatric residency at Watery National Military Medical Center, where I was able to teach and work with medical students in the field.
And did you participate in any additional training after this?
I completed a 1-year fellowship in forensic psychiatry at the same medical center in 2003.
Major Riley, what was your next step after completing this training?
After finishing my fellowship, I continued to work as a forensic psychiatrist. I held 3 different positions in the field before starting my own private military forensics practice.
And what was this first position?
So right after my fellowship, I began my 7 years service requirement as a captain in the US Army. So I first served in Iraq as a psychiatrist for 2 years, and I was the primary psychiatric consultant for a division commander who oversaw 20,000 soldiers.
And how long did you serve in Iraq?
2 years.
And what was your second position, Major Riley?
In 2006, I accepted a clinical assignment and that involves managing the hospital psychiatric inpatient unit at the Watery National Military Medical Center.
And what was your duty at the medical center?
I treated hundreds of military personnel who are suffering from a wide variety of mental health disorders like schizophrenia, but I also work with the residents and I taught courses related to forensic psychiatry.
And if you don't mind, what was your third position?
In 2011, I was the deputy director of the Department of Behavioral Health. So in that role, I continue to work in the psychiatric inpatient unit, and I provided evaluations, crisis management, substance abuse intervention, and discharge planning services to patients.
And at what point were you promoted to major?
2014.
Is this when you decided to open your own private practice?
I decided to open my own private practice shortly after in 2015.
And can you tell us a little more about your private practice?
Sure. I opened my own private practice in military forensic psychiatry because of my experience in both the military and medicine. I wanted to offer my services to former veterans who are parties in legal matters, but I also offer services to civilians.
Could you explain just, the specific duties that you do as a military forensic psychiatrist?
Sure. So the focus includes command-directed mental health evaluation, but I was trained in a course of civilian forensic psychiatry, which involves the treatment and consultation with persons involved in the justice system and courtroom testimony.
And you mentioned that you have over 17 years of experience as a forensic psychiatrist. Have you contributed any to the study of forensic psychiatry?
I published my first study in 2007. That was on military psychiatry regarding diagnosis of military personnel while deployed in Iraq.
And was this your only published study?
No, I have also written 15 peer-reviewed articles with the majority relating to forensic psychiatry and 2 relating to schizophrenia.
Now, you've told us here today that you offer your services to parties in legal matters. What experience do you have in these legal matters?
I have served as an expert witness 25 times. Seven of those 25 times come in court-martial proceedings and 18 times in civilian criminal proceedings.
And do you not normally testify for one side over the other?
I offer my services to military veterans, not the government. So the one time I was testified, I was retained by the defense.
And what are you hired to do when you were retained?
To give an opinion. To do that, I review materials like medical records, I conduct interviews, and I provide evaluations.
And are you paid as an expert witness?
Yes, that just means I'm paid for the services that I provide in my own private practice.
Of course. And what fees would you charge as an expert witness?
I charge $450 per hour to review the materials, and I charge a flat fee of $1,500 a day for testimony.
Your Honor, at this time, I would like to tender the witness as an expert in forensic psychiatry.
Mr. Simbal, do you have any objections?
No objection, Your Honor.
You will be received.
Now, Major Riley, I want to talk about your role in this trial. Now, how did you come to know Mr. Ray's case?
I was retained by your team in 2019, but I actually treated Mr. Ray back in 2010 at the Watery National Military Medical Center.
And as a psychiatrist, how do you conduct your evaluations like the one you did on patients like Mr. Ray?
So I review materials of a case to form an opinion regarding whether and to what extent a patient like Mr. Ray may suffer from including any mental disorder that would affect his ability to discern right from wrong.
What specifically, if you could help us out, did you rely on to form your opinions?
So for that, I relied on several things during my evaluation. This included his former 2010 treatment at the medical center where I met him, other corresponding medical records, material supplied to me by his counsel, and my own clinical interview with Mr. Ray, and additional interviews with his former employer, his father, and his wife.
In addition, did you rely on any medical or psychiatric materials?
Yes, I considered the DSM-5 definition of schizophrenia, his family history, his child trauma, and related mental illnesses.
And were you able to form an opinion in Mr. Ray's case using that material?
Yes, I was.
Did you form this opinion and to a reasonable degree of medical certainty?
Yes, I did.
Well, I'd like to go back to the starting point of your analysis. Could you please tell the jury or the jury more about your former treatment of Mr. Ray in 2010?
Yes. So Mr. Ray was discharged from the Army and evaluated by me for designated physical and mental conditions. It was reported at the time that he was seeing things. During my evaluation, I found Mr. Ray to be quite cooperative, and he did not have any past psychiatric history. At the time, I found he was of no harm to himself or others, so he was released 3 days later from the medical center.
And at the time of this evaluation, did you diagnose Mr. Ray with any medical illness?
Yes. At the time, I had diagnosed him with generalized anxiety disorder, and I prescribed Paxil, as well as I recommended him to follow up treatment from a therapist for his diagnosis.
And you mentioned earlier that you were able to meet with Mr. Ray for your clinical interview 9 years later once he was arrested. Was this evaluation different than the last?
Yes, it was very different. I met with Mr. Ray on September 8 of 2019. He was still cooperated as he was in 2010. But this time we spoke at length about the symptoms he experienced, and I was able to evaluate a much more detailed psychiatric history than in my previous interview.
And during this interview, what did Mr. Ray report to you in regards to his mental health history?
I learned that Mr. Ray had been experiencing many symptoms of schizophrenia throughout his life. He never told anyone because he feared he would be labeled as mentally ill and institutionalized like his mother.
Just if you could help with the jury here today, what are the symptoms of schizophrenia?
So according to the DSM-5, symptoms of schizophrenia include delusions, hallucination, which include visual, auditory, touch, feeling, disorganized speech, disorganized or catatonic behavior, and another separate set of symptoms called negative symptoms, like diminished emotional expression. A patient would have to experience at least 2 of those symptoms that I just mentioned for at least a month.
And are there any additional symptoms of schizophrenia?
Yes. Another symptom is impairment in one of the major areas of functioning since the onset of disturbance, like impairment to work, interpersonal relations, or self-care, so long as the disturbance was not caused by other medical condition or substance use.
What symptoms did Mr. Ray present?
He presented with symptoms of hallucinations, delusion, and negative symptoms, certainly for over a month. But he also shows signs of impairment of work with his wife and with caring for his own personal hygiene.
Now, to be diagnosed with schizophrenia, do you have to exhibit all 5 of these symptoms?
No.
Now, Major Riley, I'd like to walk through the history with you in regards to your medical opinion. What were the first signs that you saw of Mr. Ray when he was experiencing symptoms of schizophrenia?
Mr. Ray had been hearing voices which would come and go for years at a time since he was 10.
Did he tell you anything about those voices that he heard?
Yes. He told me that in 2015, he heard voices about his family. The voices insisted that his wife was cheating on him and that his wife and son would cut him up with a knife and leave him.
Was he able to describe these voices?
Yes.
How did he describe them?
He said they were male voices that would randomly pop up.
Did he express any other form of symptoms consistent with schizophrenia during your interview?
Yes. In 2016, Mr. Ray began having recurrent racing and negative thoughts. By 2017, he started having visual hallucination, which he described as triangles on the wall, which changes shapes and colors.
Now, did these symptoms continue?
Yes. In 2018, leading up to the incident, Mr. Ray reported that the voices and hallucinations had returned in the months leading up to October 17.
And during your assessment, was Mr. Ray able to recall the day of the incident?
Yes. He described that on the morning of Nathan Ray's death, he was feeling stressed and anxious about work. After Nathan had spilled his juice onto Mr. Ray's laptop, he began to hear voices.
And what did these voices tell him?
He heard a voice telling him that Nathan had spilled his juice on purpose and was trying to sabotage him.
What did he report that happened next?
He had punished him with physical training, quote unquote, to remove the evil. And when Nathan stopped complying, Mr. Ray became very upset and he heard a voice tell him to strangle Nathan.
Was Mr. Ray able to describe what happened after the voice told him to do that?
Yes. He said he went to his bedroom down the hall and tried to calm down. But he took a belt from his dresser and strangled Nathan with the belt.
Did he tell you why he did that?
He told me that he had just the voice, he just heard the voice telling him to do so, and he felt like he had to.
Now, did Mr. Ray express how the incident made him feel?
I asked if he thought what he did was wrong. He said he had to punish him.
Objection. This is a violation of Federal Rule of Evidence 704 in that it states a legal conclusion and thus usurps the province of the jury.
Mr. Marcus?
Your Honor, the ultimate opinion in this case is whether he understood right from wrong. This doesn't invade the province of the jury, as they're able to rely on this witness testimony and the facts and circumstances in order to come to their conclusion.
Well, my understanding is that the witness wasn't testifying as to his own opinion. He was testifying to something that the defendant told him. Am I correct?
Yeah, he's just expressing how Mr. Ray, the incident made him feel.
Right. I don't think this violates the ultimate issue rule, so I'm going to overrule the objection.
Now, let me ask that again. Did Mr. Ray express how the incident made him feel?
Yeah, I asked if he thought what he did was wrong. He said he had to punish him.
And what other questions did you ask him during your interview?
I asked whether he would have done if a police officer had been watching. He responded yes.
Now, do you consider your patient's behaviors during interviews in your evaluation?
Yes.
And what behaviors did you observe of Mr. Ray during his interview?
At the time, he was cooperative and he was coherent and he was eloquent. He was
Could you describe that change?
Pardon?
Could you describe that change a little more?
You mean the change during the evaluations?
Yes.
Oh, yes, of course. So at first he began to sweat a lot, and then he began to have a burst of anger where he became combative, accusing me of being a government agent. He believed I was out to get him.
And can you give us any other examples?
For example, he thought that I had a camera in my office microwave.
Major Riley, do you have a camera in your office microwave?
I do not.
And what happened after that?
He was able to calm down after a few minutes, and I was able to finish my interview.
Was there any additional issues during your interview that he believed you were a government agent?
Well, yeah, we stopped the interview another 2 times because he was crying uncontrollably.
Now, earlier today, the court was informed of a term of malingering. Do you take malingering to account during your client interviews?
Always. There's always a possibility, especially when the punishment is very serious.
And what are some signs that you can rely on to determine whether someone is malingering?
So there are 4 things that I rely on. Number 1, the medical legal context of the evaluation. Number 2, if there's any marked discrepancy between the patient claimed stress or disability and the objective findings. Number 3, lack of cooperation during the diagnostic evaluation or in complying with the prescribed treatment regimen. And number 4, are there any, presence of diagnosis of antisocial personality disorder?
Did you consider whether Mr. Ray was malingering?
Yes. However, I came to a reasonable degree of medical certainty that he was not.
Why is that?
Well, Mr. Ray has a detailed history of mental illness that is corroborated by previous medical records, my other interviews, detailing symptoms that began prior to him needing to establish a legal defense.
Now, you previously interviewed him in 2010, but why didn't he report these symptoms?
He didn't want to report them back then because he didn't want to sound crazy. He had just joined the Army at the time.
Now, during your interview with Mr. Ray's previous employer, were you able to gather more information about Mr. Ray's mental health?
Yes.
What were you able to gather?
His boss had told me a story where Mr. Ray had a prior incidents of violence and previous history of episodes of uncontrollable crying after physically threatening a coworker for not following directions.
What did Mrs. Ray have to offer in her interview?
She informed me of the long history in the marriage of having issues with mood swings, uncontrollable crying, and forced isolation.
Now, I want to skip a little ahead. According to criteria you relied upon in the DSM-5, what do these symptoms show evidence of?
Schizophrenia.
And do you believe Mr. Ray fits this criteria?
Yes.
And what is your ultimate opinion in this case of Mr. Ray's mental health on the morning of Nathan's death?
I was able to form an opinion that Mr. Ray suffered from symptoms consistent with schizophrenia on October 17, 2018.
Moment to confer, Your Honor.
Yes.
No further questions at this time.
Mr. Simbal, do you wish to cross-examine?
Yes, John.
You may proceed when ready.
Dr. Riley, after everything we've heard on direct, you still can't rule out the possibility of malingering.
That's correct.
That's because there always exists the possibility that someone is faking it.
That's correct.
Now, let's talk about some of the things that you look for to determine whether or not someone is faking it. One of those things would be a prior diagnosis, right?
Sorry, could you repeat it again? I couldn't hear you.
Yes, one of the things you'd look for to determine whether or not someone is faking it is a prior diagnosis.
Correct.
Prior hospitalizations.
Yep.
And is that a yes?
Yes.
And prior inpatient therapies.
Sorry, could you repeat it again?
Inpatient therapies?
Correct.
Now let's start with the first thing that you look for to determine whether or not someone is faking it, prior diagnosis. In fact, we have a prior diagnosis in this case for the defendant, don't we?
We do.
In 2010, you conducted what you described as a full and complete psychiatric evaluation of the defendant.
That's correct.
And at the end of that full and complete evaluation, you diagnosed him with general anxiety disorder.
Correct.
Not schizophrenia.
Not schizophrenia at the time.
In fact, not a single doctor prior to the killing had ever diagnosed the defendant with schizophrenia.
That's correct.
Okay, so no prior diagnosis. Let's move on to prior hospitalizations. The only hospitalization the defendant had was the one where you did not diagnose him with schizophrenia. Is that right?
I'm sorry, can I add a little more information for your previous questions?
Well, why don't you answer this question, and if there's anything that you need to add to this question in particular. Once again, Dr. Riley, the only hospitalization that the defendant had was the one where you did not diagnose him with schizophrenia.
That's correct.
Okay, so no prior diagnoses, no prior hospitalizations. Let's move on to inpatient therapies. According to your comprehensive review of all of the defendant's history, how many inpatient therapies?
Could you repeat the question one more time?
How many inpatient therapies did the defendant have?
No, none.
So we have no prior diagnoses, no prior hospitalizations, and no inpatient therapies?
Correct.
And when you have those things, they lay a foundation that allows you to not have to guess or speculate as to what condition the defendant has. Is that right?
Correct.
So I guess that just brings us to one thing, malingering, something that you must always consider, right, doctor?
Correct.
The more signs that point to malingering, the more likely they are faking it.
Sure, if you put it that way.
In fact, in a criminal setting, the more serious the crime, the more likely they will malinger.
That's correct.
And it is hard to get more serious than the death, than the murder of your own child, isn't it, doctor?
That's correct.
In fact, any time that the severity or frequency of symptoms increases in the face of criminal culpability, the likelihood of malingering increases even more.
That's correct.
An example of this would be if someone were to start to suddenly act out when in police custody.
That's correct.
The defendant, in this case, started to do jumping jacks when he was contacted by the police.
I read that.
Is that a yes?
Yes.
Now, another sign that increases the likelihood of malingering even more is when there are discrepancies between what the defendant says happened versus what actually happened. In other words, when they can't get their story straight, right, doctor?
That's correct.
Now, the defendant first told you that Nathan smashed his laptop?
Smashed the laptop?
Yes, the defendant first told you that Nathan smashed his laptop.
Yes.
But that was wrong, wasn't it?
That was wrong.
And you made sure to confront the defendant about that discrepancy.
I did.
And you noted that discrepancy in your report.
Yes.
Because it's important to take note of even the smallest details.
Yes.
In fact, had you not included that discrepancy in your report, had you not been upfront and honest about it, your report would be incomplete, wouldn't it be?
That's correct.
And as far as discrepancies go, that was the only one that you took into account, that you confronted, rather, the defendant about, right?
Correct.
And the defendant also said to you that he strangled Nathan to death in the kitchen.
That's correct.
But that's not what he told Detective Booth, is it?
I'm not sure what he told to this Detective Booth.
You reviewed all the records, didn't you?
I did. I did.
And you saw that he told Detective Booth that he strangled Nathan to death in his bedroom.
Okay, I saw it now. Yep, that's correct.
So that's a discrepancy in the facts that he told you.
Correct.
Which is important.
Correct.
And you never confronted the defendant about this important discrepancy, did you?
I did not.
You omitted it from your report.
Correct.
Which means that you didn't consider it in your analysis.
To that part, yes.
Which ultimately means that your report is incomplete, isn't it, Doc?
Well, I wouldn't say that. I mean, I did consider, the possibility of malingering, but he was also displaying all these signs and symptoms of schizophrenia.
Dr. Riley, I appreciate that, but I'm asking you whether or not you confronted the defendant about this discrepancy, to which you said you did not, correct?
Did not.
Which means that your report is incomplete, isn't it?
Objection, Your Honor, asked and answered.
Well, I think he did answer the question, but I'm going to allow him to answer it one more time.
Dr. Riley, how about this? Earlier you had said that if you didn't include and weren't upfront and honest about the first discrepancy, your report would be incomplete, right?
Correct.
So it would follow that your report is incomplete because you didn't mention the second discrepancy, right?
Yes.
No further questions.
Right. Mr. Marcus, any redirect?
Yes, Your Honor. May I inquire, Your Honor?
Yes.
Now, opposing counsel talks about the prior diagnosis and how it can lead to malingering, but that's specifically a prior diagnosis of antisocial personality disorder. But what did you diagnose him with when you evaluated him?
Generalized anxiety disorder and depression.
And why didn't you diagnose him in 2010 with schizophrenia?
At the time, he did not report any signs and symptoms of schizophrenia at the time.
Thank you, Your Honor. That is all.
All right. Okay, so let's take a break. Do you guys want a break, or do you guys want to just go straight through?
I'm open to any suggestion.
Your Honor, may I let the witness step down too?
Oh, yes. Thank you. Thank you. We're leaving our experts on the stand, aren't we? Okay, so let's take a break. Let's take a 5-minute break. When we get back, let's do a time check. And Mr. Simbal,
Yes, Your Honor.
you're the closer, correct?
Yes.
I want to give you a piece of information. Your microphone works better when you are sitting than when you are standing. Take
Okay.
that information and do whatever you want. I don't, obviously it's your choice what you want to do with the information. I just want to let you know from the court's perspective,
Okay.
I hear you better when you are sitting than when you are standing.
Okay.
Okay.
Yeah, thank you. I appreciate that.
Yes, go ahead. We'll take a 5-minute break starting from now. All right, I'm going to inquire if we have all of our jurors. Do we have Ms. McCoy?
Juror McCoy is here.
Do we have juror Di Giuseppe?
I'm here.
And do we have, oh gosh, I don't have the list in front of me. Do we have our juror?
Padilla's here.
Yeah, fantastic. All right.
Sorry. Yeah, sorry.
Not a problem. Okay, so, all right. Prosecution, you may proceed.
And before I proceed, I'd just like to state, I do appreciate the comment regarding my volume, and I decided to stand just to be able to gesture better. But if for any reason the court can't hear me, I'd appreciate an interruption so I could move closer. But otherwise, I'll try to project as best as I can.
I don't want to interrupt you, so how about if I go like this?
Okay, that works. Thank you, Your Honor. Appreciate it.
Before we begin, we would just like to put the time on the record for how long each party has left. Prosecution, you have 17 minutes, 24 seconds remaining. Defense has 10 minutes, 29 seconds remaining.
Thank you.
Prosecution stipulates as well, Your Honor.
Okay, and I'm assuming that the teams have worked out with their timekeepers if they want any sort of time signals. You don't have to tell me if you've, as long as you've worked out with your amongst your teammates if they want time signals or not.
Yes, Your Honor.
All right. Okay, so let's go with the prosecution's closing.
Can I proceed?
Yes.
Thank you. The greatest trick the devil ever pulled was convincing the world he didn't exist. On October 17th, 2018, the defendant decided that he needed to make his son, 6-year-old Nathan, understand that spilling juice on the defendant's laptop was wrong. After abusing Nathan through a series of torturous actions, the defendant wasn't finished yet. He grabbed a belt, wrapped it around Nathan's neck, and pulled. Nathan fought, but he never stood a chance. The defendant then put Nathan's lifeless body in a trash bag and tried to get rid of it. And after searching for how to get away with murder, after faking a mental illness, and after killing his own son in the most personal and intentional way possible, the defendant now sits here on the stand trying to convince you he isn't responsible. He just lost control. But ladies and gentlemen, the defendant is the one who took a fun, Frosted Flakes loving 6-year-old boy and turned him into this. The defendant has been charged with 1 count of first-degree murder. Now, we as the people have the burden of proving to you beyond a reasonable doubt the truth of this murder. We have 2 elements to prove to you today. But in regards to this burden, it doesn't mean that we have to prove it beyond all possible reasonable doubt or any imaginary doubt. We just have to prove reasonable doubt. Reason, logic, and common sense. Now let's get into those 2 elements. Let's get into the law. As the people, as the prosecution, we have to prove 2 elements. First, that the defendant caused the death of his son. And secondly, that he acted with malice aforethought. Let's start with the first element. The defendant, and nobody here, denies the fact that Timothy Ray is responsible for killing his son. The defendant confessed as much himself, which brings us to element number 2, that he acted with malice aforethought. The law states that someone acts with malice aforethought when they do so maliciously, willfully, or deliberately, and that he acts after premeditation, or in other words, that he acts after a period of reflection. And it's important to note that this period of reflection can be mere seconds. The key is the sequence of the thought process. First, there's the consideration whether to kill. Second, there's the decision to kill. And third, there's the killing arising from that decision. Now, how does that apply here? Well, even under the most narrow interpretation of the facts, when it comes to the defendant's actions, we still arrive at the same exact conclusion. He intended to kill Nathan. First, there's the consideration to kill. Remember, the defendant left Nathan and went to his own bedroom where he reflected. And after that period of reflection, he grabbed the murder weapon. Consideration to kill, done. But let's just say for whatever reason, you don't buy that. Okay, let's know the facts even further. Ladies and gentlemen, for what other purpose do you grab a leather belt, put it around the neck of a 6-year-old boy, and pull? To kill. And this isn't like pulling the trigger on a gun. No, strangling Nathan to death, taking Nathan's last breath from this earth, while he stared up at the defendant with complete fear and terror in his eyes. That takes a certain level of dedication. It takes time. Think about it. You can practically hear the screams from little Nathan. The defendant pulled tighter. Nathan struggled for air, choking. He's dying. The defendant persisted. He's made the decision to kill. Nathan's heart, chest, and although his 3'9", 45-pound little body never stood a chance against all 6'2", 180 pounds of the defendant. Nathan's body goes limp. He's dead. Nathan is dead because of the defendant's decision. At any point, he could have let go. He didn't. At any point in time, he could have released his overpowering grip so that Nathan could have lived. He didn't. He made a choice. He stuck by that choice. And now, Nathan is gone because of it. The elements for murder have clearly been met. Let's move on now to the only defense the defendant is left with: insanity. Now, the burden is shifted entirely to the defense to prove these elements to you because they're claiming this last-ditch effort. The defense has the burden to prove to you by clear and convincing evidence that first, the defendant was suffering from schizophrenia at the time of the killing. And secondly, that because of that schizophrenia, he was unable to appreciate the nature, quality, or wrongfulness of his actions. But before we even get into the details of why the defense still comes up short in meeting their burden, let's talk about why we're even here in the first place. Of course he's going to claim insanity. He's got no other options. He can't say it was self-defense. Nathan's less than half his size. He can't say it wasn't him. I mean, he did try to do that when he refused to give Officer Wentz his ID. But that plan fell apart when Officer Wentz saw the bloody shovel, bleach, and trash bags in the back of his car. So, what did he do? What was he left with? He did what every usual suspect does in a predictably written crime movie: pretend to be crazy. And to the defendant's credit, he had some people fooled. Officer Wentz thought it was unreal, unbelievable even, because it was unreal. That's why we call the board-certified forensic psychiatrist with decades of experience to look into this act and uncover the true defendant. Dr. LaGreca explained to you, with the universally accepted DSM-5 as his guide, that the defendant was not suffering from schizophrenia. As Dr. LaGreca explained, outside of the defendant's self-serving statements to his doctor in preparation for his fabricated defense, he did not suffer sufficient symptoms for a diagnosis of schizophrenia. And you don't even have to take Dr. LaGreca's word for it. The DSM-5 provides that in order to be diagnosed with schizophrenia, you must suffer at least 2 or more symptoms for more than a month. Of all the symptoms you've heard from the defense today, the defendant did not suffer 2 or more of them for more than a month. The only thing that attempts to bring it all together is the defense's practically scripted interview with the defendant's doctor. Now that brings us to the interview with Dr. Riley. Our expert, Dr. LaGreca, explained something to you that you probably already knew instinctively. You couldn't script a more serious incentive to fake an illness than when you're charged with murder. Forensically speaking, this is a massive red flag for any trained psychiatrist. Dr. LaGreca even was forced to admit that he couldn't rule out the possibility the defendant was faking it. So it should come as no surprise then that the defendant would make up symptoms like hearing voices, seeing triangles change color and shape on the wall, or seeing cameras in the microwave when he was being interviewed by his doctor for the very purpose of fabricating and manufacturing a defense. Symptoms that he never reported to his living soul until he was being charged with the death of his son. This interview isn't worth the paper it's written on. The defendant is not suffering from schizophrenia. That brings us to element 2. Dr. LaGreca explained that the crime itself tells us the defendant could tell right from wrong. The defendant, although he likely didn't realize it, confessed this and admitted this. He said that he wanted to punish Nathan for what he did. Ladies and gentlemen, you only punish someone when you understand that what they did is wrong. But it doesn't stop there. Dr. LaGreca also explained that the defendant was able to appreciate the nature and quality of his actions when he continued to increase Nathan's punishment. The defendant first yelled at Nathan. Nathan started to cry, but he didn't say sorry. Unsatisfied, the defendant forced Nathan to do jumping jacks and high knees. Nathan couldn't do it right. Angered even more, the defendant grabbed the belt and started to whip Nathan with it. Nathan cried even louder, but still, no sorry. Instead, he yelled that he hated the defendant, that he wanted his mother, the same person who cheated on the defendant and was divorcing him. Well, that was it. The defendant needed to show Nathan that what he did, what he said was wrong. He needed to teach him a lesson. And to show him just how wrong he was, with the same hands the defendant raised Nathan Ray, he grabbed the belt, put it on his neck, and took his life. And what did the defendant do? Well, he did what any suspect would do, what any murderous criminal would do, destroy the evidence. He not only searched for how to get away with killing his son, but he followed through on it. He decided to bag his son's body, bleach it, and then bury it in a shallow grave. In his own words, ladies and gentlemen, the defendant searched for exactly what he did. He didn't search temporary insanity, no, nothing like it. He typed in exactly what he knew he was responsible for: murder. That didn't stop the defense from calling Dr. Riley to the stand. The same doctor who, as you heard on the stand today, had an incomplete report because he failed to confront the defendant about a discrepancy. The same doctor who was forced to admit he can't deny that the defendant may be faking it. The same doctor who came to his conclusion without what he admitted were the foundation of a solid diagnosis. No inpatient therapies, no prior hospitalizations, no prior diagnosis. It should come as no surprise then that this doctor, the defense's doctor, was the only doctor who was able to arrive at the conclusion that the defendant has schizophrenia. Not Dr. LaGreca, not the jail psychiatrist, not Dr. DiGiuseppe, not even Dr. Riley himself after he conducted a full 3-day evaluation when the defendant had no motivation to lie. Ladies and gentlemen, don't be fooled. Don't get sucked in to the defendant's play. Hold him responsible for the murder of his son, Nathan Ray. The defendant, tell him that no matter how many symptoms he fakes, No matter how much bleach he uses, the stain of his murder won't go away unpunished. Because if it wasn't for the defendant's actions, you and I wouldn't be here today. But Nathan would be. Thank you.
Thank you, Mr. Simbal. And for the record, I could hear you very clearly.
I'm glad. Thank you.
Ms. McCormick?
May it please the court, counsel, members of the jury, evidence, not emotion. We told you in the beginning that this is what the case was about, and nothing has changed. What happened on October 17th of 2018 was an absolute tragedy. We are not here to argue that. We are not here to trick you. Because let's be clear, the defendant didn't search how to get away with murder, like the state just told you. That search was not evidence presented to you today. That is the state's trick in this case, because any search made on that phone was after Nathan's death. So we are here to explain why the state cannot meet their burden and did not meet their burden today. So let's talk about the state's burden. There is no argument. Timothy Ray took the life of his own son. But remember, the evidence has to prove beyond and to the exclusion of every single reasonable doubt that he premeditated Nathan's death. That before he planned to kill Nathan, before he killed Nathan, he planned to do so. And members of the jury, there is no evidence of this. The evidence that has been presented to you is that Mr. Ray's act was one of impulse, a snap decision after those voices finally took over. The state has presented a case of premeditation based off of solely emotion, not evidence. They told you throughout this trial that Mr. Ray wanted to hurt his son, but they never proved to you that he wanted to kill his son, and they never proved to you that he planned to kill his son. That was their only job, to prove beyond and to the exclusion of every single reasonable doubt that Nathan's death was planned. Now later today, you will receive a verdict form. And because the state did not prove the one thing that they had to, you must check not guilty. Now, members of the jury, as you can see, there is a third option on this form. And I am going to talk to you about that in just a moment. But I want to make it clear, absolutely clear, because the state did not prove premeditation, you must check not guilty. It is if and only if you disagree with me and you find sufficient evidence of premeditation, then that's when we talk about this third option. So let's talk about not guilty by reason of insanity. Members of the jury, that was our burden to bear. But you must know that our burden is much lighter than the one the state has to you today. Our burden is just by clear and convincing evidence. And as you will see in your jury instructions, it simply means that it's highly probable, that there's more of a 50-50 chance. So what is it that we proved? Well, we proved during this trial that at the time of Nathan's death, Mr. Ray was suffering from schizophrenia to the point he couldn't understand the difference between right and wrong. The state wants you to remember the trash bags, the shovel, and the bleach that was seized from his car, that it shows Mr. Ray knew the difference from right and wrong. That is simply not true. You will see in your jury instructions, knowing the difference between right and wrong only matters at the exact moment Nathan lost his life, not at any other time. And that bloody shovel that they just mentioned, just remember, there is no evidence of any blood shed in this case. No evidence that they were able to present to that fact. That again is their trick. You heard in today's trial that Mr. Ray said he would have done the exact same thing if an officer had been standing there. Is that the answer of someone who knows the difference between right and wrong? Absolutely not. That is the answer of someone who is suffering from schizophrenia, who has been suffering for the past 20 years of his life. So let's talk about schizophrenia and what it is. Members of the jury, you heard from both expert witnesses. Mr. Ray only needs to show 2 of the following symptoms for at least a month during his entire lifetime. So what's the evidence in this case that Mr. Ray has schizophrenia? Well, that evidence shows he had 4 out of the 5 listed factors, and he's been suffering for years. So let's just start with the first one. Delusions, a false belief. He believed in what his wife and son were going to cut him up with a knife. He thought Wentz and Booth were both CIA agents. He believed his own doctor, Major Riley, was a CIA agent. Mr. Ray even believed that there were cameras and microwaves watching him, recording him. Members of the jury, those are delusions. Check. Hallucinations. Mr. Ray's been hearing voices since he was 10 years old. The United States Army reported he was seeing things. He was doing jumping jacks at a DUI checkpoint. Check. Grossly disorganized or catatonic behavior. Detective Booth stood before you today and told you his evidence, his emotions, the way that he acted, they were strange. The hysterical crying that you heard about, behavior doesn't make sense like that. Check. Negative symptoms, impairments to emotions or behaviors. You heard about the mood swings and you heard about the lack of sleep. That he would lock himself in bathrooms for hours. The random angry outbursts at his doctor, at his coworker, messy hair, stained clothes, body odor, all of these negative symptoms. Both experts would agree. These are negative symptoms. Check. Which brings me to number 2 on this list, impairment in one of the major areas of functioning. And the evidence shows Mr. Ray not only struggled in relationships with others, but with himself. Throughout the trial, you heard countless examples. Struggled in a failing marriage. He attacked a coworker. He was socially awkward. And we know that what Mr. Ray looked like the night he was arrested. Just how Detective Booth explained earlier when he saw him during those weekend soccer games. A mess. Check. Now this third item, disturbance cannot be caused by a substance or another medical condition. You learned of Mr. Ray's anxiety diagnosis. And as the experts say, anxiety, it's very common. Symptoms of schizophrenia like these are not. Anxiety does not cause someone like Mr. Ray to have all of the symptoms that you heard about today. Check. You're also able to consider all 10 associated factors. The evidence shows jumping jacks, inappropriate at a DUI checkpoint. The reported lack of sleep, a disturbed sleep pattern. Mr. Ray has diagnosed anxiety. Mr. Ray's lack of insight into his own disorder, denying symptoms back in 2010. The states tried to convince you that Mr. Ray doesn't have schizophrenia because he didn't have treatment. Well, that's actually a symptom of schizophrenia. Again, that's their trick because it's right here in the DSM-5. We know he attacked a coworker, and we know that he was socially awkward. Members of the jury, the evidence shows Mr. Ray suffers from schizophrenia. The evidence shows that 81% of people do not fake their symptoms. The evidence shows Mr. Ray is part of the 1% who suffer from schizophrenia. The state has told you a story, and they want to use your emotions to ignore the evidence in this case. Now, when you deliberate, we ask that you remember, if and only if you feel there is sufficient evidence of premeditation, then you choose not guilty by reason of insanity. But members of the jury, Mr. Ray did not plan the death of his child. The state did not prove he did so willfully, deliberately, or intentionally. And that is the reason why you must find Mr. Ray not guilty. Thank you.
Does Mr. Simbal have time for rebuttal? I assume you do.
I believe I do. If I could just get on the record, a time check from my timekeeper.
Your Honor, Mr. Simbal has 3 minutes and 54 seconds remaining for rebuttal. I wasn't able, okay. It looks like defense's timekeeper is in agreement.
All right. Mr. Simbal, whenever you're ready.
Evidence, not emotion. I'm so glad that the defense has brought this up to you because that's exactly what we want you to do. We want you to follow the evidence. They may want to make it seem like every step of Nathan's death, every decision the defendant made was not evidence. It's just emotion. But to the contrary, every single step the defendant took, every decision he made was evidence. Evidence that he knew what he was doing, that he was doing it maliciously. That's evidence for you, ladies and gentlemen. If you are feeling any emotion whatsoever from that evidence, that just makes you a good human being. And if you also happen to follow the evidence, that also makes you a good juror. The facts have been laid out before you. The evidence has been laid out before you. You've had enough evidence presented to you that the defendant was in fact malingering. You've also seen a lot of check marks today from the defense. But one of the check marks they couldn't put in front of you was Dr. Riley's report. Because as you heard from himself on the stand today, it was incomplete. So follow the evidence. Follow the complete report of Dr. LaGreca that states so clearly the defendant was not suffering from schizophrenia. Ladies and gentlemen, the defendant is attempting to pull the wool over your eyes. And the defense has been doing everything they can to deflect your attention from the true matter, at the true issue before you. They've been putting so much focus today on insanity. Now, it's true that medical health issues do need to be dealt with the utmost sensitivity and seriousness. But you will be doing the exact opposite if you will find that the defendant's statements are true. In fact, you will be rewarding an imposter in the community of people who are truly suffering from mental health issues. He is using their pain to escape his responsibility. Look past the act. Don't fall for his tricks. Find the defendant guilty.
All right. Thank you very much. Judges need to complete their ballots. So I'm going to ask everybody to stay on until everyone has submitted their ballots, and then we will do brief comments. Jurors, if you can ping me when you have completed your ballot. We're still awaiting one ballot. Oh, I've got the all clear. Juror McCoy, have you submitted your ballot? I've got the all clear from the judge.
Yes.
Okay, great. Fantastic. All right. So I guess we can put ourselves back on gallery view and get comments from our jurors. I'm not supposed to give comments, but I just wanted to say thank you for a fantastic round. I really enjoyed your civility with each other, and this was a great opportunity for me. So whoever wants to go first, you guys jump in.
Hi, good morning, good afternoon, everyone. I will be first. Thank you. I want to echo what the judge said. You were all outstanding. I would be pleased to be with you in a courtroom, hopefully on the same side, because I thought you were all tremendous. I've been practicing for too many years, and I've mostly been a prosecutor. On the defense side, I did defense work for insurance companies. A lot of my practice was in chancery, but also law division, primarily in the state of New Jersey. In addition to being a litigator, I also worked extensively on legislative activities, and so I have an extensive government affairs background. So with all of that, I just want to offer that each of you was extremely effective on your nonverbal skills. As any attorney will tell you, nonverbal communication is critical, especially when you are before a jury, when you're with your client, when you're just trying to influence other people. You were all exemplary on that. Just a few keynotes. Mr. Simple, you have an excellent pace, and you present very, very well. Same thing with Ms. McCormick. You were serious, very professional, good decorum, terrific. Ms. Jackson, you had the most effective use of pauses, that you were really killing it. And your hand gestures were also very effective. Mr. Marcus, I thought that your facial expressions and your ability to do really connect on eye contact, you're going to be a killer in the courtroom. And it was just really obvious that at least you looked relaxed, as if you've been there 50 times. You were all four of you were an amazing team. I loved watching you, and I hope to see you in the future. I'm sure you'll all be very successful. Thank you.
Thank you.
I'm happy to go next since I'm already unmuted. Can everybody hear me okay? It was a great round. I echo what my colleague says, and I'm sure that juror, I can't pronounce it, Di Giuseppe will probably say the same thing. My name is Lilise McCoy. I'm a deputy city attorney in the city of San Diego. So hello from the West Coast. It's wonderful to see you all. And I'm gonna focus on two things. And these are more general comments, although I will have something very specific to say about one of them. The first general comment is, and again, you all were fantastic, but I want to give you something to chew on, to improve on. And the Zoom competition works, which is fantastic. None of us knew whether it would work 6 months ago, but this is the second competition, law school type competition I've judged, and I'm very pleased that it works, but it is different. So the thing that I'm experiencing as a juror, and if I were coaching you, I would say that I think it's really important to focus on things like vocal variety, pausing, enunciation, and being deliberative. And all of you had some great moments, but all of you also had moments where you spoke too fast, you didn't use effective pauses. In a courtroom setting, I can get some of that with your body language. And I know 2 of you chose to stand and 2 of you chose to sit. Either way, I'm missing the full experience. I'm missing the movement in the courtroom. I'm missing the full body language that I would get if we were in real life. So I think somehow that needs to be compensated for in these Zoom competitions. And I think the only way that it can be done, and I haven't really thought it through, and I should say I ran the trial team program at Thomas Jefferson School of Law, where I'm no longer running it. I passed it on to one of my former students, but we did win Tyler Regional twice. So we've had some good experience. We have a good team, solid team. And if I were coaching still, I would tell them that they have to be extremely cognizant of how to overcome some of the limitations in Zoom. And again, the only way that I've been able to figure it out so far is additional vocal variety, additional pausing for effect, making sure that you enunciate the words that you really want the jury to remember, and then being really deliberative in your delivery. The second thing I want to talk about is one of my pet peeves, and that's no conclusions on cross-examination. And Mr. Simbal, you gave us a fantastic opportunity, super duper teaching moment on that. And that's when you were doing it was a good cross-examination of the expert witness, but you tried to get him to answer your question. So that means your report was incomplete. You didn't need to go there, right? And he got you, right? And even during your closing, all of which was good. And you're all guilty of it. I'm guilty of it. We're all guilty of it. Mr. Simbal, I don't mean to pick on you. You just gave me a great opportunity for a teachable moment. When you do that, you open yourself up, and it made it harder for me to believe you in close, when you said his report is incomplete. You just didn't have to go to that final piece. You said it. You got him to admit, you didn't consider this in your report. It's not in your report, is it? Right? Your report does not have this information in it. That's all I needed from you. Otherwise, great round. I can see why Drexel advertises this competition as selecting the best teams in the nation.
Hi, guys. My name is Samantha DiGiuseppe. You all did a great job of pronouncing my last name, so I was really excited about that. I just graduated from law school last year. I am a law clerk in New Jersey, so while I can't speak to any level of professional practice as our other 2 jurors can, I competed in mock trial for many years, and I most recently did a Zoom mock trial competition over the summer that was one-on-one. So I do think I have a little bit of experience with what you guys just went through. And I think you all did an excellent job. I know how hard it is to transition from doing mock trial competitions that are in the courtroom to doing this online. So I commend you on that. This was also a really close round for me. So I think that speaks to how well all 4 of you did. And I know we don't want to keep you here too long, so I'll be quick. So I really just have general feedback that I think can apply to both sides. My first piece of feedback is you guys need to listen to each other's objections. There were multiple times throughout the trial where somebody was objecting on a certain ground, and the presiding judge was really great in that she would say, what are your grounds? What are your grounds? And then the person responding would just respond how they wanted and wouldn't really respond to the grounds that were asserted. So make sure you guys are just listening to each other. I know it's nerve-wracking, but I noticed it. In terms of pacing and style, I'm going to pick on Mr. Simbal and Mr. Marcus a bit. I think when you guys get excited, you tend to speed up. There were multiple times throughout the trial, I did not know what you were saying because you were moving so quickly. Miss Jackson and Miss McCormick, I think both of your pacing was wonderful. And I could hear both of you very clearly throughout the entire trial. And then my last point to both sides is just, I read the case file. I think there are a lot of really good pieces of evidence. I think it's a very well-balanced case. And I think you need to pull that evidence out a bit more. So for the defense, obviously you're asserting that your client is schizophrenic. I know that there is a lot of pieces of evidence in this case file that lend very nicely to that, and I didn't hear a lot of that. I think I heard the phrase CIA agent or CIA over 50 times, and I wanted to hear more as to why this person was schizophrenic and to connect that a little bit more to why he was not responsible. I kind of felt it was like repetitive evidence. And then for the prosecution side, I think that you need to remember that in a real trial setting, the jury doesn't know anything about this case. And for the opening, Miss Jackson, that's really the first time the jury is hearing anything about this case. And I felt like, I don't know, and again, it's a stylistic thing. I felt like you kind of just dove into things. You were naming people without explaining who they were. You were talking about schizophrenia without explaining what schizophrenia is. You can't assume that everybody knows what schizophrenia is. So I felt that was a little bit, I was confused. And I think Mr. Symbol, your direct examination, you didn't lay qualifications or really a lot of foundation as to who we were learning from. So then when Mr. Marcus got up to do his cross, I think he did a really good job of discrediting your witness, because I didn't really think your witness was that qualified to begin with, because you didn't really tell us that. So these are just points where you guys can pull out the evidence a little bit more and make your case a little bit more solid. But overall, I actually think this was a really good round.
Okay, thank you all. Great job. Good luck this afternoon. And you may now sign off Zoom.
Great to see you, presiding judge.
Oh, good to see you, Lilies. It was really nice. I hope you're doing well and staying safe.
Same. Take care.
Bye.